case, okay?
Yeah.
We're gonna give you a bond sheet. You can approach my reporter will hand it to you. And you can take that. We're gonna send you over to the prosecutor. You'll talk to the prosecutor and then you'll come back in here, okay? Have a good day. Or I'll see you either way back in here in a few minutes. What, any sentencings ready? Is Cantu ready? Francisco Cantu ready? Daniel Curtis Giles, 25T646053A and B. I don't know. Good morning, counsel.
Good morning, Your Honor. Tim Gambler, P78192 on behalf of Mr. Giles is also present.
Your name, sir? So as I understand it, he's going to plead guilty to 2 counts of disorderly.
One count.
1 count? Why a no contest plea? Call in Mr. Bologna, John. 249, I believe it would be. What's the basis for the no contest plea? Was there?
There's gonna be continuing legal action, Your Honor. The condition that he's in right now was a result of what happened during the incident. So the no contest plea, I believe, contemplates future litigation.
All right, let me get the prosecutor in here. I just need him to clarify something. Mr. Bologna, your appearance? Good morning. I just want to clarify, it's 1 count of disorderly, right?
It was an A and a B.
I know, and you got disorderly and
Yeah, 1 count, yes.
which count? Do you know, you care?
I don't care.
Why don't you just write on here, if you don't care, count 1 or count 2, and I'll take the plea on that one. And the reason for the no contest plea, was there actually an allegation, counsel, of, in other words, is there a possibility of civil litigation on this, Mr. Bologna?
Yes, sir.
Let me just double check. I would think in an assault case, but I want to double check something here. Do you have the police report in here for me?
I have it right here, Your Honor. If you'd like to look at it.
Yeah, I'm gonna need to have that marked.
Yeah, bro.
Yes, you can add it to my recorder there.
I have it as part of the discovery package.
Wait 1 second, slow down. Maybe I can just have this one marked.
Separate one.
Why don't you give me a separate one? If you can always bring those in on a no contest plea, it would help. So do you understand what you're doing here, Mr. Giles? You understand you plead no contest to 1 count of disorderly, which I suppose would be count 1. That's what he's written down now. That I'm going to dismiss both counts, count 1 and count 2 of assault and battery. Do you understand that? And you understand a no contest plea has the same effect as a guilty plea. You can. And you understand the possible penalties on this are up to $500 in fines, 90 days jail, costs, or all of those. Do you understand that?
Yes.
Can I have you staple this? Is this the only police?
That's it.
You're on.
All right. And I'm sorry, you can have that staple that market People's 1.
Your Honor,
Hang on.
if I may, there was also a body cam in this, which we attempted to get, but I believe it was protected under HIPAA. And I think the officers had indicated that they will at some point allow us to maybe look at that and redact together, but we did try to get the police, that we couldn't get the body cam, and also with the discovery, no witness statements and no photographs of alleged injuries. So I would just point that out.
Well, that's between, if that pertains to other litigation, that's between you and Mr. Bologna and the circuit judge, and whether or not there's issues raised of HIPAA violations or potential HIPAA violations.
Quite that whole story.
Okay, so I've had this marked People's 1. You stipulate I can use this, Mr. Gamber?
Yeah.
And Mr. Bologna?
Yes, sir.
Sir, did you sign, read, and understand an advice of rights form here today? If you plead no contest, you will be giving up all the rights on the advice of rights, and we are not going to have a hearing or a trial. Do you understand that? Any questions before I ask you how you proceed, how you wish to plead? I'm sorry?
No.
All right. To the charge of disorderly person, how do you plead?
No contest.
All right, let me review this. Are you on probation or parole? I can't hear you.
No.
And I find there's a factual basis for the plea. Has anybody forced you to plead guilty?
No.
All right, I'm gonna accept your plea to count one, disorderly, no contest. Again, I find there's a factual basis. I'm gonna dismiss count one, original charge of A and B, count two, A and B, refer you for a pre-sentence report. Didn't see anything in here about, let me just double check. I didn't see anything that he was under the influence, so I'm just going to order a PSI. We'll give you a sentence date. He's going to undergo a PSI today. We're going to notify the victim, Amy.
We can do the 12th, February 12th at 8:30.
That's good with me. You good, counsel?
That's awesome. That's great.
February 12th at 8:30, sir. We'll see you back here. Thank you.
Thank you.
Thanks, Mr. Ronya. Thank you. Dylan Lane Haynes, 260-647-075, and I'd like Celia Renee Pixley Zakowski seated at this table here, my right, your left. Come on up to the podium, Mr. Haynes. Tell me your name.
Dylan Haynes.
You're charged with drive while unregistered vehicle. You have the right to a lawyer. Would you like a lawyer?
Sir. Sir.
Okay, you go out in the hallway, we'll give you a lawyer. Okay? Celia Renee Pixley Zakowski, 260-647-514, A and B. Come on up to the podium, ma'am. And tell me your name, please. This guy needs a lawyer. You're charged with expired license and also driving with an expired plate. Expired license is a misdemeanor. You have the right to a lawyer on that. If you'd like, then I'll give you one. Otherwise, I will arraign you and send you to the prosecutor. Talk. I can't hear you, ma'am. Okay, just keep your voice up nice and I'll go ahead and arraign you. On January 10 of 26, it is alleged that you did operate a motor vehicle on Fort Freeland in Trenton at 8:39 p.m. Drive while license expired as a misdemeanor, punishable by up to $100 in fines, 90 days jail, costs, or all those in 2 points. Do you understand that? And you're also charged with expired plate. That is a civil infraction. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that? All right. You still wish to waive your right to a lawyer? I'll enter a not guilty plea, $100 personal bond. You don't have to post any money. You have to comply with these bond conditions, though. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You go outside, the prosecutor will call you. We're going to bring this file to the prosecutor, and then once you talk to the prosecutor, you'll come back in here. Okay? Thank you. Francisco Elijah Cantu, 25F244-762A.
Good morning, Your Honor. Mr. Chairman, may I have my please?
All right. Mr. Cantu, your name?
Francisco Cantu.
All right. So your client, Mr. Shemke, pled no contest operating while visibly impaired. There was an accident here. He was referred for a screening and assessment. But before you go on, I need to make sure, Amy, that there's not a Timothy Roberts out there, either in the courtroom or on Zoom. He was notified he is the victim. Anybody out there?
There is no Timothy Roberts on Zoom.
Thank you. Have you had a chance to review the report, counsel, and are there any material additions, corrections, or deletions?
I have, Your Honor, it's factually accurate.
Anything you'd like to say on his behalf?
Yes, Your Honor, my client's done extremely well on bond. Still had gainful employment. I put the terms and conditions. I do believe they are appropriate. I believe he could put himself in a very favorable position for early termination. That being said, Judge, he works somewhere between 55 and 65 hours a week and more. I potentially just ask consideration for as an alternative to the workforce for the community service. But otherwise, I believe all those conditions are appropriate. I have no further requests. Thank you, Judge.
Sir, anything that you would like to tell me before I sent you?
No, Your Honor.
And this is your first contact, but you're only 22. This kind of scares me that you're here already. I was telling you. You understand?
Yes.
Okay. All right, 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to appear as directed. No alcohol at all. You're not to purchase, possess, or consume any. No marijuana, no illegal drugs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs. They're recommending it appears bi-weekly throughout. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll make it monthly. So make sure all those tests come up negative, okay? You understand? You're to attend the substances abuse group through Class A Training Center. You're to attend the Victims Impact Panel. This does no contact with the victim at all. I'm going to order 4 days jail, credit 1, serve 3. I'll let you do one of those by way of community service, but the other 2 are going to have to be done on the court work program. 1 day community service. I'll give you until March the 15th to complete that. 2 days on the court work program. There's a $35 a day charge for that, for a total of $70 in court work program fees. So far, do you understand the sentence?
Yes.
Okay. This was a infoxilizer, correct, counsel?
Yes, Your Honor.
So I'm going to give them cost of recovery of $150, $300 in fines, $250 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $675. Cost of recovery is $150 for 8 1/4. Screening fees $60 for 885. Probation fees are $240. So your total there amounts to $1125 plus the court work program fees. Your total is $1,195. If you violate, your probation could be revoked. You could be eligible. You could be incarcerated for up to 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Also, you may be eligible for early discharge. You stay out of trouble, no violations. You come in here in 6 months. You fill out a petition. By law, you're entitled to early discharge. Okay? You understand all that?
Yes.
All right. Does he have all this to pay, Mr. Shemke?
Do you need a payment plan? Yes, Your Honor. I'd ask that,
You can pay it all.
in this circumstance, Judge, I'd ask that, if he's eligible for early termination, his balance would be paid minus the potential extra 6 months of supervisory.
Well, we'll return that.
Okay.
Ma'am, you gotta take that phone out of here.
The phone has to leave the building, ma'am.
Ma'am.
Phone has to be out of the building.
They gave you that phone?
Yeah.
Who's they?
Who's that?
The door.
All right. We will refund that if he's granted early discharge. Okay, sir, you're gonna meet with the probation department, okay? Go down, pay your fines, and then go over to probation, and they'll instruct you.
Thank you, Judge.
Thanks a lot. Have a good day. Holly Darnell. Holly Ann Darnell, 25T647138.
Good morning.
Good morning. Your name? So you owe 185. You need time to pay.
Yes,
Do you have anything today?
I have 45 on me right now.
Okay, when can you pay this?
Can I pay a little bit the following Friday and then the rest of it the following Friday?
Sure. How much can you pay on each? I'll tell you what, you pay 45 today. You pay the balance at rate of $50 per week. I'll give you a little extra time, 50 per week, and we'll start that on February the 6th. Is that good?
I appreciate it.
We'll make it February 9th so you can get it here. If you need more time somehow, no worries. Come talk to me on or before the due date or call the court. Tell them we need to go on Zoom. I'll go on Zoom with you. I'll grant you an extension on or before any due date. I don't care how many times.
Oh, thank you. I appreciate it. Times are hard right now.
You know how many people take me up on that though? They say thank you and then they don't call and instead of, so I don't care if we have to do, I'm just telling you, I don't care how many times we have to do it. All right?
I do appreciate it.
Good luck to you. Thank you. Mark Daniel Purdy, 25T645104. Mr. Purdy, come on up here, sir. Your name?
Mark 30.
All right. Illegal firearm transport is the charge. You have the right to an attorney. If you would like one, I will give you one. Would you like an attorney?
No.
I'll go ahead and arraign you on January 9 of 26 at 8:39 in the morning. The police think that you were on Medford or Belmont and Trenton and that you illegally transported a firearm. It says defendant was located inside his vehicle with two pistols in his center console, unloaded, but with one magazine loaded in the center console and another in the glove box. That is a misdemeanor. And in your CPL, they say expired in 2018. That is a misdemeanor under local ordinance, punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form?
Yeah.
If you plead guilty at any time, you will be giving up all those rights. And we are not going to have a trial of any kind. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer? Not guilty, pleas entered. I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You're not to possess any firearms. No firearms. You're not to possess any firearms. If you have any, you have to surrender those to the police department, Trenton, within 24 hours. And you were printed on this, and also no contact with prosecution witnesses except through your lawyer. Do you understand all that?
Yeah.
All right, so go talk to him. And I'm going to put this on here. Where you're going to wait outside in the hall, and the prosecutor will call you when he's ready to see you, and then you can come. You're going to come back in front of me either way. Okay. Good luck. People against Alan Fonseca. Which ones do you have?
I have the sentencing on Collins.
I'll call that next. Alan Fonseca. See here?
No,
Lynn
Judge,
Fon-
sorry.
Go ahead. I'm sorry.
The police department just wanted to dismiss that one, so I pulled it.
So the prosecutor wrote up this failure to respond to civil infraction. He sent it in. I can't read what he said, 5 pond or something like that. But at any rate, he's moving for dismissal. Case is dismissed. That's again for failure to appear for a civil infraction. People against Collins, Devin Tyler Collins, 25B149-7738. Good morning, Mr. Schwab.
30720, if you have Mr. Collins.
I also have a B file here. He pled under 7411. That is the possession of a controlled substance, which is cocaine. And he also pled on the drunk driving to the charge of operating while visibly impaired. He was referred for a screening and assessment. Have you had a chance to review that with him? And are there any material additions, corrections, or deletions?
Chance to review with him. I thought that the drug case was marijuana.
Wait a minute. No, I don't think so.
I know you.
They found it prints out possession use of a controlled substance, but this is the one where he acknowledged to the police that he had cocaine in his pocket.
Well, I wasn't the original attorney.
Am I right or am I wrong, sir?
You're correct.
Did I ask you your name yet?
No, thanks, Devin.
Okay, so it was the cocaine. And he, was referred for a screening and assessment. Have you had a chance to review the,
I have your honor.
report, any material additions, corrections, or
You
deletions?
just be back, yeah.
Okay, anything that you would like to say on his behalf?
Just your honor, that I believe that he has, tried to address the problem, has gone to the A meetings, he has abstained from any alcohol and drug usage, he's a working man. It's a little light working during the, winter time, he does catch some things.
Okay,
And, so
he's spending all his money on cocaine though. What's he doing? Go ahead, I'm sorry.
I think that, he's right now, he's saving a lot of money because he's not doing it.
Well, that's good. That's good. Mr. Collins,
Yes, sir.
what would you like to say? Anything?
Not really, just I apologize for my.
Don't apologize to me, apologize to yourself. You know what I mean? You're a nice looking kid. You seem to have a lot going for you. Get away from that stuff. And the marijuana too, right? I mean, come on. Don't do this to yourself. I hate to see kids like you or anybody, frankly, get themselves in trouble. You just seem like you got a lot going for you, and that cocaine is miserable stuff. Did I let you finish? I'm glad to listen to anything else that you'd like to say.
I do have my 2-month coin from AA. I've
Fantastic.
been going 3 times a week. Basically ever since the arrest, I've been mostly clean as a whistle, basically up until about 2 months ago. So
Wait a minute, Base. Say that again. The offense was in October. We didn't have a pretrial on this till December 18th. What do you mean? I thought I heard you say I was clean as a whistle up until 2 months ago.
yeah, after the arrest, about I was still smoking a little bit, and
I see.
then after about 2 months ago, I was going to stop altogether.
All right. You have proof of your AA attendance? Can I see it?
There's 2 separate ones because I misplaced one of them. So there's a couple on, there's mostly on one of them and a couple on another.
All right. Who do you live with?
Myself.
You own a house? You rent a house?
I live at my grandma's old house and paying off her mortgage right now, living there.
Okay, don't lose these anymore. I'll take it your word. I'm gonna hand you these back. Can you approach Mr. Schlaff? Will hand those back to him?
Yeah.
And he's going to stay out of trouble. I know he is. Right, Mr. Collins?
Yes, yeah.
All right. 12 months probation. On file A, it's not under any statute. In other words, there's no 7411 or anything else, but it is on the B statute. So if you're clean, you do everything I tell you to do, that's count 2 on motion to prosecutor is going to be dismissed. Because I'm taking it under that statute. You understand that, right?
Yes, sir.
So 12 months probation, all these terms are going to run concurrent. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. I do want you submitting the chemical, kratom poppy seeds and CBD oils are prohibited, by the way. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs bi-weekly. The cocaine has me even more concerned than the other. You're going to do that for 5 months. If you're clean, I'll then make it monthly. So every other week, you're going to test, and I expect you to test, okay? We want to make sure you stay off of that. You understand?
Yeah.
All right. 4 days jail, credit 1, serve 3. I'll let you serve all of those on the court work program. There's a $35 a day charge for that for a total of $105. Again, I'm attributing the fines and costs primarily, unless I say otherwise, and all the common costs on file A. So you're also to attend and complete an outpatient substance abuse treatment program. You're going to continue going to AANA 3 times a week until you're in until you're in outpatient treatment. And you are also to attend the victims impact panel. So the quicker you get an outpatient, the better. If you get in this week, you no longer have to go to AA or NA, but you do have to complete outpatient treatment. You do have to attend the victims impact panel. Do you understand everything I've said so far?
Yes.
All right. In terms of fines and costs, on the A file, the impaired file, $300 fines, $250 costs, $75 victims' rights fee, $50 justice assessment, $675. Screening fee is $60 for $735. Probation fees are $240 for $975. You have cost of recovery of $218 for a total of $1193. You have, I'm going to just assess $40 in attorney fees for a total of $1233, plus the court work program fees of $105 for a total of $1,338. I'll go light on your fines and costs on the other case. It's simply going to be 100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. The screening fee, probation fees, cost of recovery fees are all going on the A file. So you owe $325 plus $1338. That would be $1663. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge, certainly on the impaired, and the prosecutor certainly can move to dismiss the 7411 if he is satisfied once you file your motion for early discharge on the A file.
Your Honor, if I may.
Sure.
Is it possible for him to do some extra community service in lieu of some of the costs?
You can't pay these fines? I mean,
During the winter, I work like a part-time job, because my job is seasonal, so.
here's what I'm gonna do.
After the time during.
I'm gonna let you pay $50 a week. And I'm gonna do that on the A file. And I'm gonna start that beginning on February the 27th. I'll give you a little bit of leeway time. So I'm gonna only have you pay $50 per week starting that date. If you need more time, you can come talk to me. After you pay the fines on and costs on that, you're gonna pay on the B file. So after fines costs paid on the A file, you'll pay them on the B file. If you're really running into trouble, you come back in here, file a motion. I'll be glad to entertain that request for you, okay? I'll give you a review hearing date right now, which is going to be 12 months out on the 7411, the drug charge. What do you have for me there, Amy? It should be in January of 27, God willing, if we're all here, Mr. Sloth.
Good.
It's going to take her a minute. That's the next year's calendar.
January 27, we can do the 14th.
14th is good. January 14th at 8:30 in the morning. Okay?
Yes, sir.
Now that's independent of the other case. So if you do everything, there's no violations, you feel free to make your motion for early discharge in 6 months on the impaired charge. And usually the prosecutors will then go ahead and dismiss, move to dismiss on the other. Okay? I wish you well. Thank you, Mr. Schlaff. You're going to meet with probation before you leave here, okay? Thank you. Destiny Sade Triplet. 24T641933A. 24T641933B. 23G305620A. 25B149805R. Your name? Ms. Triplet, you have to start your video.
Oh. Destiny
Your name?
Triplet.
Your name?
Destiny Triplet.
Why am I gonna give you time to pay when you've been playing with us for so long? I'm serious as a heart attack here. I'm serious. Are you this irresponsible or just with your court business? Hello?
Yes, I can hear you now.
Did you hear what I said?
No, can you repeat that?
Yeah, I said, why would I give you time to pay on this when you are this irresponsible with your court business? I don't know if you just do it with courts or you do it in your everyday life, but this is ridiculous. You owed us money since 2023 on one case. You owe us money on another case from 2026.
I just need a little.
Did you pay the fines and did she pay the fines and costs, Amy, on 25B 149805R? Do you work?
Yes, I just paid Southgate. A
I didn't
Southgate
ask you
ticket
that. Where do you work at?
Allied Universal
What do you do there?
Security.
How much money do you make?
Right now I'm part-time,
How many hours?
20 hours.
What do you do the other 48 hours that we have in a week?
Well, I'm a cybersecurity student. I'm in school and I have 2 children I'm taking care for by myself.
Amy, can you tell me if she paid that one?
On the R case, she
Yeah.
owes 120.
Did I give her a due date of January 29th?
It looks like you gave her a due date of January 14th, January 16th.
Ma'am, I hope you have a piece of paper right handy because I'm going to rip this off. So if you don't, get a pen. You have a pen and paper, ma'am?
Me, yes.
I'm only talking to you. Okay, I want
Yes.
to make sure you understand this. On that civil infraction, write this down. 25B
25B
149
149
805R.
805R.
Correct.
054.
Pay that by February 27 of 26.
Okay, I can do that.
On 24T, write this down, 24T 641-933B. That's 24T 641-933B. You're to pay this by March 31.
March 31.
That's like $212.
212. Okay,
We're not done.
okay.
And I'm going to cut you this break because at least you had the courtesy to come in and talk to me, but you cannot do this. Is Trenton ready out there?
Ready.
Let's take that one next. Then on 23G 305 6208, that's 23G 305 6208. You pay that by April 30.
April 30th. 30th.
And then on the last one, 24T 641-933A, you owe 405. I'll extend that time. You're supposed to pay that by February 28th. You pay this by May 31. If you don't have any of the money on any of these days, you call the court, we'll go on Zoom again, but you got to be more responsible, young lady.
Okay.
I don't know what else to tell you. I mean, I'm sympathetic that you're raising 2 children on your own as the prosecutor in their lives. I'm sorry, is the father in their lives?
Yeah, sometimes.
All right. Are you collecting child support?
That's what I'm working on now. Yes.
All right. Good luck. If you need more time, call the court. Kazonia Trinice Harris, 26T 724-943.
Okay, thank you.
Welcome. Sorry
Your
about
Honor, we're gonna go with Ms. Harris.
Okay. Who has Ms. Harris? Mr. Shemke, your appearance?
Yes, ready, Judge.
This is the only one I have, right? Escape.
Ms. Harris, you stand here on the red X. Okay, when the judge speaks to you, you speak up, okay? Right here.
Your name, ma'am?
Kenzonia Harris.
Okay. You sound like you're in a bad mood. You in a
No,
bad
I was
mood?
asleep. No, I was
What?
asleep.
Well, I don't want to wake you. You want me to put you back in lockup until I can arraign you here if you're that
No, I'm
drowsy
listening
or?
to you. I'm listening to you.
Well, thanks for that. I appreciate that. Mr. Chumke, your appearance again, sir.
Good morning, Your Honor. Christopher Shepke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
Ma'am, I'm going to advise you of your rights. You have the right to remain silent. You're charged with stealing or retaining without consent a financial device, transaction device. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yeah.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor at the preliminary exam. If it goes that far, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, that charge would be dismissed and you would be discharged. Do you understand that?
Yeah.
Okay, so make sure she fills out a petition, will you please, Detective, for a court appointed?
Yep.
February 10th.
Yes, Your Honor.
At 9:15, you'll be in front of Judge Hesson. That's for the PCC. February 17th at 11:30, you'll be in front of Judge Hesson for the preliminary exam. So February 10th at 9:15, February 17th at 11:30. What would you like to say regarding bond, counsel?
Your Honor, just that I believe my client has a limited criminal history. I believe that she is on probation. I'd respectfully request consideration when determining an appropriate bond. If she's not eligible for a personal bond, I'd ask for a 10% and or cash surety provision. Thank you, Your Honor.
How about you, Detective? Anything?
Your Honor, we leave that up to the discretion of the court. I'd just like to let you know, though, that she does have a Third Circuit warrant for no bond to pick up as well.
Oh, that's too bad. You got a couple warrants. I would have given you a personal bond. You don't like to show up in court, huh? Don't make this worse than it is by not showing up. 7,500, 10%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Pamela Wojciechowski. You cannot write, phone, see, text, email her, or communicate with her, or have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses. We'll let you make calls. I hope you can post. You have to post 750. I wish you well. Good luck. Thank you.
Thank you, Your Honor.
Thanks, Mr.
Thank you,
Shemke.
Judge.
Turner, Larry Allen Turner Jr., file 22G305387. Come on up to the podium, sir. Which one do you have, counsel?
I have Sterling Wright, the sentencing.
Okay, your name?
Larry Turner.
I'm going to go ahead and dismiss your case on motion of the prosecutor, I presume, because your daughter's, you graduated, right?
Yes.
All right, good luck. You're all set.
All right, thank you.
Thank you. Let me real quick take Pixley Zachowski, Celia Renee Pixley Zachowski, 260-647-514, A and B. File A is driveway license expired. File B is expired plate. Your name, ma'am. All right, you're going to plead responsible to expired plate, true?
Yes.
You have a valid plate now, right? You showed that registration to him? To the charge expired plate, responsible or not responsible? Do you plead responsible?
Yes.
All right, I'll accept the plea, dismiss the drive while suspend, revoke, denied, or rather the drive while license expired. 135 is your total. You move right down the end of the hall and take care of that, and you're all set. Good luck. Sterling Wright. Sterling Joseph Wright, 25R 514-323-25F 244-059. Mr. Wright, how are you? Your name?
Carmen, B7324, I have the clinic, Your Honor.
All right. So we got a $100 cash bond on the civil infraction that I set, and also a 1,500 10% bond on this misdemeanor. So he's been in custody since I did that back on January 27th. So he has 2 days credit coming from that. He was referred for a screening report. Have you had a chance to review it with your client? And are there any material additions, corrections, or deletions?
Your Honor, I've had the chance to review that claim with Mr. Wright, and I'd like to bring the court's attention to a couple things. Regarding an employment, he is working full-time as a laborer. The name of the company is Wheel Deal, WHL Deal. That is in Flat Rock, here in $20 an hour. He does now have a 3-month-old daughter, and they all live with his parents in Flat Rock. And as far as his health status, about 2 weeks ago, he was in a serious car accident, so he suffers nerve damage in his spine, and he's currently on arthritis pain relief due to that. Mr. Wright has been in custody for 3 days. I've gone over the recommendations of probation with him. He understands what he needs to do, and would ask that the court adopt those, please.
Anything you would like to say?
Like I literally basically said, basically about that's basically everything. That's I was going through.
I can't hear you.
My lawyer basically got everything I'm going through.
Why are you doing this to yourself? I do not want you to say one word admitting or denying what I'm going to say. I'm charged with it. They didn't have enough evidence. But when I read this report, I can say to myself, these guys were going to break into cars. Don't say anything. You can't do this. You can't do this. I mean, you can do it. And then you're going to get caught. And then you're going to go to prison. And you'll note that I said prison, not jail. Prison. You know what I mean when I say prison, right? You know, yes?
Yeah.
You know why you know that? You know why you know that? Tell me why you know that.
Family has been very.
Well, because you've been around the system too. You got a felony going on right now, right?
And then
Mr. Right. It's your life. It's not mine. It's not your lawyer's. It's not anybody else's. I've seen this movie. All it is a replay. Sometimes the movie gets uglier. Sometimes it takes longer to play. I've just seen this movie, this picture, hundreds and hundreds and hundreds, if not thousands and thousands of times. And I'm pretty good at predicting. And I'm telling you, the way you're acting, you're not heading to jail, you're heading to prison. Now it's your life. Again, I wouldn't want to go there. Remember when I was a young lawyer going into the Wayne County Jail with some of those guys, they stunk, their breath stunk, and I had to talk to them. In a cubicle about 5 by 4. Everything about them stunk. You want to go to prison with those type of people? Continue on this little journey that you're on. I'd like to see you turn it around. How old's your daughter?
3 months.
How great that would be if she's 6 and says, well, my dad, I haven't seen him 3 years, but I'll see him when I'm 21. He's in prison. You can do that if you want. You struck me as being a nice kid who's doing bad things. You're sleeping with the wrong friends, son. And I don't mean literally sleeping. You're hanging out with the wrong kids. Maybe you're the leader. I don't know. Maybe they're following you. Who knows? The first thing you need to do is go back and get a GED or a high school diploma. I don't know how anybody gets a job that's worthwhile if you don't do that. You don't have any learning disabilities, do you? So you just didn't study at all in high school, right? You just didn't try, right? Right?
But that wasn't it. I ended up going online, and I had ended up leaving by the end of the year to go work full time.
Yeah, but why were you going online instead of going in person? Whenever somebody tells me they went out online, you know what it tells me?
Yeah.
I'm going to take the easy way out. I mean, there's a lot of things we can do to take the easy way out, right? I think so. You know, you can watch anything, any profession, any sporting. I don't care what you're watching. A lot of people take the easy way. It's easier to take the easy way out. I want you back in school. I want you getting a high school diploma or a GED. I want you staying away from these people that you're hanging around with that are wearing masks and trying to break into cars at night. You got me? Don't admit anything. Go to work. You're young, you're strong. I can tell by looking at you. You work 65, 70 hours a week. It's their prime earning years for you. You get old like me and just me in here, then it gets tougher.
Sure.
You got it?
Sure.
All right, let's get you back on the right track. 12 months probation. This is all on the open intox. I'm going to try to not do all this because I know I'm going to be watching you not comply.
But
Listen, I want you to be one of those guys that writes me a letter in 2 years and says, thank you, Judge, you helped me. That's what I want. You want to do that, or you want to just end up in prison? 12 months probation. You cannot leave the state without the consent of the court or violate a law. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, no violations of law. We understand that. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. They want you to test bi-weekly for 12 months. I don't, because I know you're not going to do that. But I am going to make it bi-weekly for 3 months. And if you're clean, then I'm going to make it monthly. You got it?
Thank you, Your Honor.
Then I'm going to have you go to AA. I know you probably weren't doing it before on December 11th. You didn't go to AA, did you? When I ordered, you didn't do that, did you?
But
Yeah, I'm just asking you a question. Did you?
I didn't go.
Yeah, I know you did. You didn't go because I know you didn't go. I know because I just know. We're going to give you another form. You're going to start going. And you're going to that until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to go to AANA. So do we understand each other so far? All right, you spent 3 days in jail. I'm going to give you 3 days credit. I'm going to order 5 days jail, and I'm going to let you do the other 2 by way of the court work program. You know why I'm doing that? Because I'm going to trust my little conversation with you is going to help you reflect and think about where you're going with your life. You're only 19. You got 75 years ahead if you want it. It's nice to see you smiling. 2 days court work program in lieu of jail. So I'm going to release you on this case as far as this case is going. $70 in court work program fees. You have to clear all your warrants. Now that's going to take money. They want it to be done in 30 days. I don't think you can do that. I'll give you all the way to April the 1st to do that. I'm going to assess fine. I'm going to go light on your fines. Fines 100, 75 costs, 240 in probation fees, $75 victims' rights fee, $50 justice assessment. All that's 540 of a $60 screening fee for 600 and court work program fees of 70, your total 670. If you violate, you could get 90 days. If you comply, you're eligible for early discharge in 6 months. And you know what I'm going to do for you, Mr. Wright, just so I can get you off to the right start. You owe $210 on file 25R514323. I'm just going to make a note. Defendant spent 3 days jail. I'm going to waive the balance of those fines. How nice is? Well, it's all for naught if you don't do that. Remember, I'm also ordering you to get a GED or a high school diploma. You're doing that for youth, for your daughter. You realize your daughter's like 100 times more important to you than you are, right? So you got to raise a good daughter here. All right? Come on now. I don't want to see you back here. Except to ask me for early discharge. Please don't come back and see me. I'm going out of my way here. What's that?
So you saw leaving.
Get that diploma. Stay out of trouble. Life's a lot more fun. Work. Burger King, McDonald's, on top of your other job. I don't care where you go. Go to a hardware store. I don't know where you go. Good luck.
Thanks.
Oh, by the way, I gotta set up a payment plan, don't I? Wait a minute. I'm sorry. Come on back here. Mr. Wright, I'm going to let you tell me how much you can pay and afford to pay and when. How's that?
Me and my lawyer talked about 150 a month.
I don't want 150 a month. Okay? I don't think you can pay 150 a month right now.
Well, the duration of the whole probation, 36 months.
You owe 670. I'm going to let you pay $65 monthly. Beginning March the 1st, but I'm not going to discharge you unless you have it all paid, with all money due by November 1 of 26. Okay? Got it? You need more time? What are you going to do?
Contact you, my brother.
Contact me. You can either come in here on or before the due date at 8:30, or you can call the court, go on Zoom. Was there something else I needed to address?
Further on.
Good luck. Stay out of here. Okay?
Thank you.
You're a nice kid. Act like it. Priority waste. It's 266-474-14A and B. All right, Mr. Dillon, I feel like you and I are getting to be good buddies. I see you every single day, it seems like, in here.
Yeah, that's true. Good morning, Your Honor. Alex Dillon on behalf of Priority Waste. I do have Nick Sage with me as a corporate representative. We have resolved the case. The misdemeanor is going to be dismissed. We're going to pay a $500 fine.
So you're going to plead the mislug 2 axles. That's on file A. Agreed
Yes.
upon fines and costs of $500. And file B, the misdemeanor will be dismissed, right?
That's correct.
And you're authorized to enter that plea on behalf of the company.
Yes.
To that charge, misload, responsible or not responsible?
Responsible.
Please accept it, $500, paid by, I think I gave you March the 15th.
Yeah.
Well, at least they're keeping the lights on over here, Mr. Dillon. Pay by March 15th and file B is dismissed, okay?
Yeah, we're catching up one day at a time. I appreciate you.
No problem. Have a great day. Good to see you.
You too.
All right, come on up here, Ms. Wolf. Susan Lynn Wolf. The officers here on this. Is the officer here on this? Officer Jones? There you are. Come on up here. I'm sorry. I don't recognize half you guys anymore. Your name?
Also, David Jones.
So Ms. Wolf, they offered it impeding. She got really upset, said she didn't understand. This was at the department rep hearing. And even though she's not here, she sent me some kind of a letter. I didn't read it. about how I didn't understand, and maybe I didn't. I don't know. I think I did. I think she was just playing with me, but any problem with me reducing this to impeding?
No, Your Honor, I had given her the 2 citations, and I actually told her if she was able to renew her license, I'm sorry, her plate, I would dismiss that ticket, and I figured that she would be already impeding that, no problem whatsoever.
So I'm going to indicate the fault judgment, but police officer agreed to reduce to impeding on file A, which she was offered but declined, got upset, whatever you want to call it. And fines costs here, Amy, will be $150. If they have a way of communicating, tell her she can pay $15 per month beginning March the 7th, and the 7th of every month thereafter. You all right with me? I don't think she got her plate renewed, or at least I have no evidence of that. You all right with me just dismissing that?
I did check her out. I mean, she did renew it.
She did.
She did.
Wow. Motion of the officer. So you make that motion to dismiss that?
Yes. Your Honor.
So we'll dismiss the expired plate just to give her a break. She seemed like she didn't have a lot of money, and just think that's appropriate. Thank you. How long have you been there now?
Just shy of a year, I've been testing city payroll.
Yeah. Okay. It's just hard to keep up anymore, you know?
So it's like 20
Good for you. I'm in my 43rd as a lawyer, and
Amen.
have a good day. Thank you. How you doing? You just want to come in and say hi?
Just need John.
I think he just walked out about 2 minutes ago.
Okay.
All right, Ms. Matejzek, I hope you're, I can't do much for her, Mr. Dabolski. Courtney Elaine Matejzek, 25R724360.
Good morning, the record, Brendan Dabolski, on behalf of Courtney. Yes, and the scheme.
Ma'am, your name? So let me start by saying here that, and she's off the Adderall now, right?
Correct.
It looks like you're doing good on bond. The prosecutor's office has consistently said 60 to 90 days. I've argued with them over the language. They've left it to my discretion. But there's no way I can justify not sending you to jail today. I'm going to listen to what your lawyer said. That will help you tremendously. But there's no way I can rationalize not doing that in my brain. Mr. Dabolski, have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
No, we
Ah.
reviewed it and there are no additions, corrections or deletions.
All right. What would you like to give me your excellent words of wisdom, as you always do, so I can do the best I can for her here?
Well, thank you, Your Honor. With that being said, before I dive into all her redeeming qualities, I just want to remind the court, yes, this was reduced from the prosecutor's office. And with that being said, Your Honor, I know that you said it's hard for you to deviate your mind from the jail time, but
I didn't say it's hard for me to deviate from the 60 minimum days. I'm not saying that. Go ahead.
Well, I was going to just remind the court that according to the plea agreement,
I know, I've completely.
could waive all.
Exactly. I know. No, I know that. I know.
So,
For the longest time, they sent me minimum 60 to 90 with work release if eligible.
Correct.
And then it was if they do anything wrong at all, or they don't make it through, I have to give them a year. And I fought with them because they're not the judge on the probation violation sentence. I am. And I don't mean to sound uppity about it. I just mean prosecutor's office should not be telling judges what to do in the event of a probation violation. I fought that war for years, and I finally got it where it's reasonable. But she's got 3 offenses. She had a 2-3. She's the ripe old age of 34 years old. And that's where we are. So go ahead. I'm going to listen intently. I promise you.
Standing before the court, my client is 34 years old. Okay, she does reside in Farmington Hills. She's here today with not only her mother that's seated directly behind me. I believe it's in the second row, but behind her, there's 2 individuals. Number one is her sponsor. So she's taking it upon herself to obtain a sponsor. And not only that, there's an individual seated next to the sponsor that is in charge. He's very involved in AA. I think his court, he said he's dealt with this court in the past. He's familiar with this court.
Mr. Wells, who got through the sobriety court. I'm really, really, really proud of him. So proud of him. We put him as a supervisor on our court work program.
Oh, and that's a testament to how well he has embraced sobriety.
He's done. He gave me some gray hairs and some fits, but yes, he did. Yes, he did.
Well, he's taking it upon himself to stick his neck out on the line for my client. My client, from the very beginning, obviously there's bond conditions. My client has complied with those bond conditions. Your Honor, made reference to that. She's an individual, first and foremost, Your Honor. The reason why she's getting into sobriety court is because she has a problem with alcohol. Okay. Yes, there were 2 priors. She was charged with a felony on this 3rd offense. It was reduced. She was given a break. It was reduced to a 2nd offense with sobriety court. She got it. Let me remind you, and I'm not saying that in a disrespectful way, but Your Honor, I had brought it to my client's attention that when she was working out here at the time at Leo's Coney Island, I guess on the report it indicates that she is employed there. She kind of is, but she's not working right now. She's on leave from there, so technically she could go back, but she's taking a leave of absence to focus on her sobriety, which she truly needs to. So with that being said, she's taking it upon herself to not only attend AA 3 times per week, which brought proof here. No,
I believe
feel
you.
like you trust me.
You don't have
but
to show me. I believe
I
you.
do have proof of all that. She's involved with an individual therapist once a month. She she obtained the sponsor. Okay. She's doing IOP right now, but she's in compliance there. She has really kind of, for lack of better terms, grabbed the bull by the horns here. And she has embraced the fact that she is the type of person that can't drink, not just for this period of time while she's in sobriety court, while the case is pending, but for the rest of her life. She has gotten sober in the past, Your Honor. However, she was, like many of the individuals that are in that situation, they think that, if you just slowly go back and you don't drink as much, you don't really have an issue with alcohol. She'll be the first one to tell you she's an alcoholic and that she can't ever drink again the rest of her life. Matter of fact, we've spoken at like many a times throughout the duration of this case, and she has indicated that it's not her friends that she's blaming for getting into trouble, but the people that she was running with just weren't people that were helping her in life. Matter of fact, now that she's sober, she's come to grips with the fact that sadly these people probably weren't true friends, because now that she's not frequenting bars, hanging out and drinking at parties, they're not involved in her life. And she realizes that those aren't the type of people that she wants to surround herself with anyway, because she has lofty goals to turn her life around. She has been spared a felony conviction on her record, but most importantly, she's going to remain sober. She knows not only for just sparing trouble in the future, but for this case, she could go to jail for up to a year, but just to get her life back on track. I'm not using this as an excuse, Your Honor, of why she relapsed. I kind of want the court to understand what was going on at the time. And it's like I said, it's not an excuse. She'll be the first one to admit that she chose to drive the car on the night in question. Thankfully, there was no accident. Nobody was injured or even worse, killed. The police officer actually pulled her over prior to her driving. She ran out of gas. right on the, right on the road. But nevertheless, with that being said, she has taken a positive approach to this. She even indicated to me that this is kind of crazy to hear this, but it's the best thing that could have happened to her. The reason why is because it caused her to realize that she's not one of those people that can just drink, once in a while. She can't drink at all for the rest of her life. And Your Honor, just like that speech you gave that young man, two people before me, before my client, she's in the same boat. If she goes back to drinking, she's going to be like that gentleman if he doesn't clean up. He's going to end up in prison. And that's what happens when you can't identify, problems in your life. And she has to understand what her triggers are, and obviously remain vigilant against those, and stay sober. And I think this program is truly created for individuals like my client who have a problem, who want the help, who are going to actually gain something from getting that help. And I have no doubt in my mind, I'm standing up next to this young lady right now, and I've known her for a long period of time, but I have no doubt in my mind that she's going to do everything Your Honor orders her to do. She has, I know that she was ordered by the probation department to refrain from taking the Adderall. She has stopped taking that Adderall, as Your Honor indicated.
But she got clearance from her physician, right?
She did. She did.
Because we just won't accept anybody, but probation, we stand very short of telling somebody you got to get off of medication. We only say, if the doctor thinks you need it, fine, but we can't accept you. So I just want to clarify that into the program. You follow me?
100%.
Okay, go ahead. I'm sorry.
I mean, she doesn't think it works as effectively as her new medicine, as effectively as the old, but at the end of the day, this is what she wants. She really wants us to go there. She wants you to allow her into it. However, one thing I will say, unbeknownst to Your Honor, and I wouldn't bring this up, but I think that, considering that, she's an individual that has a problem with alcohol. Yeah, if she was on bond, if she went back to drinking, Your Honor would throw her in jail, and it wouldn't really solve the problem. She could do, roughly, do her probation, 30 days in jail downtown if it didn't get reduced, and be done back, back doing what she wanted to do. She didn't want to go that route. She was fortunate to get this. And during the inception of this case, she's dealt with a lot. I have a letter from her doctor right here. Unfortunately, she has some pretty serious health concerns. They just detected.
Hand that up.
Yeah. It doesn't state everything, Your Honor, but I will say, yeah. Your Honor, at her last doctor appointment, they detected some
some like high-risk cells that
I see. You don't have to talk about
correct,
it.
but long story short, surgery is required. So,
I'd like to have a copy of this for the probation file.
something that's pretty serious.
So I want to make sure that you take this back, but I'm going to have a copy of this in the probation file. Go ahead.
Needless to say, I'll summarize it. It's a very serious medical condition that requires surgery. Obviously, thankfully, Your Honor is caught it. But I know that Your Honor sees this as someone that has to be punished because of the number of offenses. I'm asking this court to give my client a chance. She understands, Your Honor, that if for some reason you were able to see it that way, any violation, I'm so confident she's not going to violate. I'd say any violation, give her what you would typically give someone in this situation. But I think because she's gone to great lengths to prove, not only, no offense, not only to this court, but to prove to herself and her family that she can do this.
She got through the 35th District Court Sobriety Court program in 15, right?
Correct.
Did you graduate? That scares me, though. In a lot of ways, it scares me that was a second offense. You did that, you came out, and we're going to take a chance on you again. I don't usually put people in a sobriety court on when they've already done it, at least in ours, but I happen to think that we do pretty good with this. And I'm only saying, go ahead.
Well, Your Honor, I don't want to cut you off. One thing I sometimes get sidetracked with. What I was saying is, I don't want to use it as an excuse, but what her mindset at the time was, is that her best friend in this world was her grandfather. And right before this incident happened, she had watched her grandfather's health rapidly decline. As a result of that, in order for her to cope with seeing her grandfather's health decline, she would use alcohol, she used it excessively. And thankfully, nobody was ever injured when, she was driving that day. But right after this incident happened, as a matter of fact, her grandfather passed while she was in jail. Took a huge toll on her. Clearly, she's emotional now. You can see how much that, just passing of that individual has affected my client. Thankfully, she didn't resort to using drugs or alcohol to cope with the loss. She did use alcohol to cope with continuing the decline in health. But, she's firmly committed to doing everything Your Honor orders her to do. I would ask, Your Honor, not to give her any jail time, allow her to do the probation, allow her to do work program. In lieu of that, she has another issue with some spots on her face that the dermatologist has to send out because he's concerned about issues there. She's going through it. And I would just ask you to allow my client to prove to this court that she's taking this matter seriously and that, any violation, Your Honor, give her what you were initially thinking of giving her today. But to take a flyer on her and allow her to prove that she is an ideal candidate for not only this program, but to prove to you that she's going to do everything this court orders. She's not doing it just to, pacify you. She's doing it because she wants to help and she's a new person. I would ask you to, take all those statements into consideration and obviously avoid the jail time. But my client does want to address the court herself as well before the matter.
Sure, go ahead. Take your time, relax. Do you want a Kleenex or something?
Can I grab one?
Sure. You got them around here somewhere. Right there. Right here.
Thank you.
I just want to take a moment to, tell you thank you for giving me the chance to do this. And like he was saying that, I did resort back to old ways because I was in medical advocate. It was hard to watch him pass. It was hard to watch him get sick. And I'm sorry to cry.
You're fine.
I was scared. Before it happened, I was scared of how I would drink after it happened. And I think this is a blessing. I feel like, it happened to me that way. I could be sober when it did happen. And, I was sober. I've been sober since incident. I was released on the 13th. My grandpa passed on the 14th. I was able to be there with him. I was able to hold my promises. I do take full accountability. I understand what I was doing was wrong. And, I didn't know that there were consequences. And I just really feel like things have been, I've been blessed to have this opportunity and to, be there to honor his wishes and his last moments. And, and then the therapy, the AA, a lot of it's doing well. I've met great people. I've been attending the meetings. I met Brett there, and then I had the impression that just the way he carried himself, and that I seen him here, and I was like, wow, like it just really inspired me. And I met my sponsor at another meeting, and I attend as much as I can, and it's just been beneficial. And on a lot of that, I was lacking with my own health concerns. So these last few months, I've been able to take a lot of things on that I wasn't really concerned about while I was medically advocating for my grandfather. And I do appreciate everything you guys are doing here and allowing me into the program and different opportunities to move forward. I do see that like, remaining sober is beneficial in my best interest because like, when I didn't drink with my recent diagnosis and I didn't drink alcohol. And, when my grandma did pass and I really have seen like, no way of life and that it does just cause me more problems and it does help and
You were in custody for one night at the time of this arrest. Is that true or false?
Correct, Shirley.
Just give me a second, okay? Some lawyers think this job is easy, Mr. Polsky.
I would never think they, face some difficult decisions every day.
Twenty-four months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're not to go to any place where drugs are being sold or dispensed or used. You can go into a drugstore. Those are drugs, but that's not what I'm talking about. You can't go to parties. You can't go to drug parties. You can't go to bars. I'm not going to consider it a violation if you walk into a 7-Eleven because they sell beer either. But if their primary source of business is selling alcohol, you're not to go there. You're to submit to chemical testing, PBTs and ETGs when probation tells you to. They're going to have you test for the longest time 3 times a week, and then ultimately it will reduce to 2 times a week. They're recommending 60 days on the sober link going forward. I'm going to require 90 days. You're to attend 12-step meetings 3 times a week and provide written proof of attendance. You're to obtain an AANA sponsor. I know you said you have one, but you're to notify probation of that. You're to attend all substance abuse treatment in an approved facility. and provide written proof of attendance. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Program. You have to report to sobriety court review hearings with me every 2 weeks. Obviously, in the off weeks, you'll be with the probation department, reporting to them. They'll let you do a lot of that by Zoom. You're to obtain and maintain employment with proof provided to the probation department. You are to pay fines of $200, costs of $300, $75 victims' rights fee, $50 justice assessment. So your fines and costs are $625. There's a screening fee of $60 for $685. You have probation fees of $480, bringing your total to $1,165. You have sobriety court fees of $360, bringing your total here to $1,525. I'm going to order 72 days jail, and I am going to tell you how I'm going to break that down. You have, like I said, $1,520 in fines and costs, 72 days jail, credit 1. You're going to serve 6 on the court work program. There's a $35 a day charge for that. Your court work program fees will therefore be $210. So your total should be, and if you don't mind checking this, Heather or Amy, whoever's in there, the total should be $1,735. I'll let you set up terms of payment with probation. So your initial, so I'm ordering 72 days jail, credit 1. I'm going to let you serve 6 on the court work program, like I said. I'm going to let you serve 5 by way of community. And I appreciate the fact that you're coming all the way from Farmington Hills, but that's just, I'm going to require that. 5 days of community service by May the 1. You're to serve 60 days jail beginning. You're going to give me a review hearing date, Amy and Heather, please, for about 2.5 months from now. You're coming back on that date. You're starting your 60 days. You will come in here for that review hearing. If you're compliant 100%, not 99, I'll probably not require you to serve any of that jail time. If there's any violation, you're going away. Do we understand one another? Can you guys give me a review hearing date? I don't care what day. In just the
You say
middle.
about 2.5 months, like the middle of April.
Yep.
We can do April 15th. I think that might be one of your sobriety court days, so.
We'll do it on April 15th then at 8:30 in the morning. I would be highly, highly, highly unlikely to give you jail if you're compliant, but it has to be 100%. If it's not, you're going to jail. Do we fully and completely understand one another? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You could get a year if you violate. If you don't get through the program, you're likely going to do a year. I'm going to do this for you. There's something in my gut that tells me that you're going to be compliant. But I'm telling you, I don't want to come across as threatening. You have no idea what kind of a break you're getting here today. And if you don't comply, you're not going to like me. You get through this program, you'll actually like me by the end. Not if you don't comply. I'm going to let probation set up terms of payment. I don't have to take any revocation act or immobilization action. The last was in 15. That's the other thing I'm looking at. First was 9, then 15, then 25. You know, some will think it's too easy. Some will think I'm too. That's the price we. Good luck. I hope I don't have to send you to jail. Thank you very much.
Thank you.
All right. Can I have Dylan Lane Haynes? 260-647-075. Good luck, ma'am. You're going to meet with probation. They might tell you to come back later, okay? Because our probation sobriety court probation officer isn't here. Thank you. Good luck. Dylan Lane Haynes.
Thank you.
Thank you. This is 260-647-075.
And good morning, James Long.
County Public Defender's Office. Your Honor, to the extent that there's a conflict, we would waive any conflict. When we agree with the prosecutor, we'd ask the court to waive any conflict, or any potential conflict or thought of a conflict in these matters.
And the court, for its part, does not believe there's conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Kenyon Jackson.
Alex Jablowski for the People.
David Goldstein to bring on behalf of the defendant.
All right, Mr. Jackson, can you state your name, please?
Hey, Al Jackson.
Thank you, sir.
Your Honor, Mr. Chabalowski and I have had an opportunity to discuss these matters. This matter is going to have to be sent, these matters are going to have to be sent to circuit court for resolution. My client was unaware of that because he's in the Macomb County Jail. But Mr. Jackson, we're going to work out a deal for you in circuit court, just like we did in Macomb. So we need to waive exam, just like we did in Macomb. Is that okay with you?
Yes.
All right. So, Mr. Jackson, you understand that you're waiving your right to have a preliminary examination in these matters?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing on these matters and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all charges.
Your Honor, we acknowledge receipt of informations in both files. My client waives the reading, stands mute, asks that a not guilty plea be entered.
Trying to find the case. I have 4 counts on the I have 4 and 3, correct?
Correct.
All right. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea as to all 7 counts. Pretrial in this matter will be set for
February 23rd at 1:30 before Judge.
February 23rd, 2026, 1:30, Judge Hamoud.
Sorry, Judge.
Hamoud.
I thought you said Judge who?
I did not call
It's
it.
going to be one of those days, Judge. It's going to be one of those days.
All right. Bond will continue.
Thank you, Your Honor.
Thank
you. Court calls the case of the People versus Demarion White.
Sir. Morning, Your Honor. Please have a court David Burtis on behalf of Marion White, who's appearing via Zoom from the Juvenile Center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are working toward a resolution. It's probably going to get bound over eventually, but we need a little more time at this level. So we're just asking for a couple weeks adjournment, Your Honor.
Returning to 12. All right. Probable cause conference will be adjourned to February 12th.
Thank you, Your Honor.
2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you, sir. Court calls the case of the People versus Margaret Patowski. Yeah. Patowski? Yeah, she's in Zoom, I think, but I need an attorney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Patowski.
Ms. Patowski, can you state your name, please?
Muted. A case law in there, because everything else was.
Ms. Patowski, can you state your name?
Margaret Patowski.
Thank you.
There you go.
Your Honor, there was an offer made in this matter, and I did meet with Ms. Patowski at the Department of Corrections yesterday, and I as soon as I left the department, was able to leave the department and get to my cell phone, I did reach out to Mr. Childers to let him know that she intends to accept the offer. Unfortunately, I don't believe he received it in time. It was like 4 o'clock, although I had a 1:30 appointment.
I'll then adjourn this out 2 weeks to the 12th, February 12th, 2026, 9 a.m.
And I apologize, Ms. Potowski. I know you.
The bond will continue, and hopefully then I'll have the paperwork and we can get it all settled. Okay, Ms. Potowski?
Okay, thank you.
All right, thank you. Court does call the case, People versus Procopio Vitale.
Morning, Your Honor. Raymond Cook for the people. On behalf of Mr. Vitale. Good morning, Judge.
Good morning.
Mr. Vitale will be approaching. Please state your name for the record once you get up here.
Procopio Vitale.
And if you wouldn't mind just signing here.
What are we doing?
Your Honor, today's date, time set for probable cause conference. We will be waiving the preliminary exam at this time. Mr. Vitale is executing a waiver form right as we speak. Handing it to Deputy Allen.
Is that correct, sir? Yes. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute as to reading or waive. I got there eventually.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for February 12th, 2026, 1:30, Judge Slay.
Okay, thank you, Judge.
Bond continued. Thank you. Calls case of the People versus Tiffany Peters.
Go on behalf of Ms. Peters. Judge, it's a turn AG case.
I think it's an AG case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Judge, this is a PCC matter. I had a long.
Want to state your name?
Oh, I'm sorry, Robert G. Kill on behalf of Ms. Peters. Sorry about
Ms.
that.
Peters, can you state your name, please?
Tiffany Comer Peters.
Thank you.
Judge, Ms. Peters is living in West Virginia now. This is a child support matter. She's current in her payments as far as monthly payments. I'm asking for a 30-day adjournment. Again, I had a long conversation with her last night. She can make between now and then, within the next week, she can make an $800 payment. And we're hoping she can bring this amount down to where we can work this out short of a felony, but we need some time to do that.
Gonna be any objection from the people regarding that?
No, I would just like the attorney to get in contact with our office, but no objection, Your Honor.
Gonna call their office?
If I know who to call. Yes, I will, Judge.
Thank you. Probable cause conference will be adjourned then to February 26th.
Thank you.
Thank you, Judge.
2026.
Thank you.
9 a.m. Bond.
Thank you. Appreciate it, Mr. Very.
Court calls case of the People versus Gary Carmichael.
David I. Goldstein, appearing on behalf of the defendant. State your name,
Gary Carmichael. Thank you.
Setting this matter for exam, Your Honor. I do have all the discussion.
People have their witnesses available to 10.
Your Honor, I'm going to be gone the month of February.
The whole month?
Yes.
That's right. He held on something else?
No, Your Honor. I was going to make a bond motion in a moment, Your Honor, but
are the people going to be opposing a release in this case?
I would just ask for a tether as well as a potential silver leaf.
Okay, here's what I'll do. I'll Will March 3rd work for you?
Your Honor, I've got a trial starting on the 2nd. I can do the 10th.
So what I'll do is preliminary examination in person, March 10th, 2026, 9 AM before Judge Washington. What I'll do at this point is I'll have his bond continued. You two send a stipulation over with the conditions and then I'll sign off.
All right, thank you.
All right.
Thank you.
Thank you. Court calls the case People versus Randall Laird. AG. Just that for AG.
Morning, Your Honor, Assistant Attorney General Doris Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dottie Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
You're requesting an adjournment. I did just receive a full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the page. 26. Yeah, so let's do it that way. All right, probable cause conference in this case will be during February 26, 2026, 9 AM. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Mr. Patton, can you state your name, please? Just Mr. Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That's correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor, punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, sir.
And that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, sir.
understand that? Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North of Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
Seven, 8:30 before Judge Perry.
February 27th, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
He was the first here.
Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're going to find a way to.
I can find a way.
Test. Because if I let you out, we're going to end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated.
Thank you, Your Honor.
Conditions.
Thank you, Your Honor.
Thank you. This is what I need to do. CC order. Just want to put back to her. Court does call the case People versus Michael Padola. Yeah, I see him. Here's his attorney. Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedola.
I'm gonna pass your case. We gotta wait for your attorney to show up.
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena, so.
And then we have the people.
Your Honor, I'm sorry, did you call Bedola? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court. Kadena Gale Self.
Thank you. You're requesting an adjournment?
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th,
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver, hit 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to the car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe or additional charges. Calling someone names isn't enough.
Well, the
But as for the,
stamping with a screwdriver, that would do it, wouldn't it? You don't need to say anything.
just-
Motion for
just-
bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. Court calls case People versus Edna Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Karma.
Good morning, sir.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other. But you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes, sir.
that on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just
expect-
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
But you don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What I'm
I don't know
saying,
who the heck you are, but if you start yelling in my courtroom, you're gonna be going with her.
okay, this what happened on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Right. What I'm saying is on the 5th, I was dirty. I had used like not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold on.
still
That's what I was getting at before your fans started yelling out from the.
my sister. She here
All
from
right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
no,
test.
No, I had.
You had
since
not
the
used
5th.
any cocaine,
No.
even though you've been using it for years.
Right. Right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
I can check levels.
I wish
but
y'all
not-
would.
But, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
So now-
Grant an adjournment in this matter to February 5th, 2026, 9 AM. That's 1 week out.
Your Honor,
You're not available that day?
correct.
That's fine. I'll set it into 12. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my
You
sister.
know, you need to take yourself on out. What? What last one? Oh, was it? Did you ever say that? Want me to repeat it? No, that was. You don't get that response. No, she's what? You don't want to talk to me about that? No, okay. Court does call the case of People versus Terry Probst.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, who's making his way into the courtroom, I would assume.
Well, where is he?
Exactly.
Evan is custody.
He is in custody, Judge.
Oh,
Just give that back to you. Yeah.
we'll pass it.
Okay.
Court does call the case People versus Quan Patterson.
Freeman Cook. Cal Kavalowski for the people, Your Honor.
What? Who's that?
That's Mr. Probst.
Oh, I'll just take him if you got him. All right, back on the Probst matter.
Morning, Your Honor. Raymond Cook.
Okay, sign that. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination.
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that's alleged or committed. And you committed.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right.
Yes, Your Honor, there was an offer put down on the record.
Yes, go ahead.
The offer was completed to the filing 1391 motion for dismissal filing. Trial.
All right. Good.
That is correct, Rich.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute, in the charge.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst is was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. He the missed tests he reports resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to the, he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. But most for bond reduction tonight, bond will continue. We'll bring it up. Thank you,
Judge.
Court calls case People versus Quan Patterson.
Cal Kavalowski for the people.
Is that Mr. Goldston, Your Honor?
No, Mr. Goldwell took over the case. Oh.
Okay, then.
Mr. Kilowatt is on Zoom in another court,
Who?
or I'm sorry, Mr. Goldstein is, sorry. He's trying to wrap it up, so he's not gonna be able to come in for a couple of seconds.
Is the client here?
Yeah,
Oh, okay.
client is here. And I don't have stage fright.
Why are you sending us the messenger? You wouldn't even stand up at the beginning of the docket. Now you're delivering message. No, I don't want to talk to you. Bye. Court calls the case of the people versus Bradley Potter.
Alan, on behalf of the people.
Ron Brown, attorney on behalf of Mr. Potter. Mr. Goldstein standing in for Mr. Fikowski.
Seriously? Okay, we can't, no.
You want me to go get him?
The one you were delivering messages for.
Tell him Bradley Potter's up.
Bradley.
Sorry.
Your name, sir? Bradley Potter. Thank you. None of this is your fault. This is.
Goldstein standing in for Mr. Fikowski.
Do we know what they're doing?
Setting exams,
Setting it for exams?
both of them. Mine
Okay,
too.
so based upon your knowledge, the discovery is complete.
That's my information.
And so you want your matter set for exam? Is that what?
Yes,
you're
sir.
All right, very good. Would the people have their witnesses available to 10? Preliminary examination will be set February 10th, 2026, 9 a.m. before Judge Garwood.
Hey, I just said it for you.
Okay. Bond will continue.
It's February 10th. Judge Garwood.
Thank you. I'll tell you. And, all right, thank you, sir. We already took care of it after we got the message from your messenger cannon.
She couldn't do the waiver of.
That's what I was saying, but she was delivering messages for people. I don't know what her deal.
Judge, I approach in a related matter to this.
To which one?
Mr. Popowski.
Oh, sure.
I'm standing in for him today, Your Honor.
Quan Patterson.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir? Quan Patterson. Thank you.
Your Honor, we do have all the discovery, including the videos, and we're asking the matter be set for free.
People have their witnesses available to March 10th. Yeah, that's what I said. Is there a problem with that?
I hear it most judge.
Your Honor, if I could address bond.
Go ahead.
If I can address bond real quick. My client, the magistrate, for whatever reason, saw fit to place a tether on my client, a GPS tether. It's not a curfew. We're not sure why exactly. He wasn't ordered to do any testing. I've known Mr. Patterson for a number of years. He's a lifelong resident of this county. He is not a risk of flight. He works in this county. He lives in this county. He has family in this county. So we're not sure why the magistrate, I wasn't present at the arraignment, Your Honor. Not sure why he did it. We're asking the
Do you
court.
have anything else pending?
No, Your Honor. No. And all I can say about this particular case, Your Honor, is I think whoever the judge at the prelim is going to find the video very interesting.
Give us a moment, we'll get you notices, is there anything else?
Any response from the people? Those ears, no, go ahead. I didn't know if it was the ears or not. Go ahead. What?
I think that there was, the tether probably was related to, some recent, at the time of charging, some recent cases that, have been pending or were recently dismissed as exam.
They were dismissed.
There in prior history, I don't necessarily have any other explanation.
That's
So
correct.
you're indicating at the time that the arraignment happened, there was other stuff pending.
Right, which was then subsequently dismissed.
That's what I.
Got it. Okay, with the understanding that there's been a change in circumstance on this, I'll grant the request to remove the GPS tether. So we'll prepare an order and let them know so you can get that removed even before you leave here. Just go over. Yes. Okay. I'll set preliminary examination in this matter, March 10th, 2026, 9 a.m. before Judge Garwood. His bond and its monetary amount will continue without the.
Thank you.
Thank you. Court calls case People versus John Marks.
David I. Goldstein appearing on behalf of the defendant.
Your name?
John Marks.
Thank you.
We're setting this matter for exam, Your Honor. I do have discovery.
People, other witnesses available March 10th.
Do our best, Your Honor.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continue. Calls case People versus Javante Cadell.
Morning, I'm Rob Dickel on behalf of Mr. Cadell. Javante, would you state your name on this podium?
My name is Javante Cadell.
Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available February 10th.
Do our best, Your Honor.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Fresh Hour. Esteban.
Judge, this young man's 18. He has no criminal record, juvenile record. It's my understanding, he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. He would like to get back to the Ozone so he doesn't lose his place as far as getting a placement, and he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion, but if it helps the court decision making at all, the co-defendant's case that was set for exam on Tuesday and got dismissed because we were unable to proceed at that time.
Got it. How do you come back into custody?
Were you arrested or did you?
I was arrested, sir. My casework was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
Trying to get to one of my friends' house. But sir, I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to my my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir.
You're going to appear for all future.
If it was too cold, then we're getting soft.
Nah, it wasn't even just that. I didn't have the right clothing either, sir. And I was building
I got you.
Through the distance.
I got you. Well, reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir.
You call me, okay?
No, sir. Let me just see real quick.
Those previous bonds stated.
See right away here. boss.
Thank you, Judge. Appreciate your consideration for this young man.
Court does call the case People versus Gary Coward.
Morning again, Your Honor, Honorable Court, David Phillips, on behalf of Gary Coward.
Gary Coward.
Your Honor, myself and Mr. Chavalowski are trying to resolve it at the district court level. If I can come back on the 12th, I'm back here again, Judge.
Probable cause conference without objection will be adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Text you.
Court calls the case of the People versus Caitlin Quinn.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy, P 33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them and at this time knowingly voluntarily waived them and lay a factual basis to the added count.
May I have her sworn? Raise your right hand. Do you solemnly swear and affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep, yes, Your Honor, yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
yes, Your Honor.
On the date of September 4th, 2025, Washtenaw Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use
No.
cocaine after.
No, well, go ahead, Counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail since, she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on a PR.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case, People versus Jennifer Burnside.
The people.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present standing.
Morning,
by.
Your Honor.
Good morning, your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There is also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29, 2026. And there is a sentencing judge where we checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes. May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service to court teams necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of prosecution as well as the cost of any emergency governmental services. Do you understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
I do, Your Honor.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce? You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. And why'd they stop you?
My turn signal was burned out when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you to commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
All right. And have I complied with the court?
Yes, Your Honor.
The court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked it. He has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response from the people.
Judge, we'd ask, being Oda Mayor in the next going to this Friday court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th, and then Judge
That date can be moved up. I'm not moving it up because I don't have a date.
Fair enough.
So you guys can do that, and if you can get it moved up, then that's fine, and I'm not going to remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.
I just need a form on that.
Yep, okay.
Court does call the case People versus Marquetta Clement.
People.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs with and on behalf of Ms. Clements, who's approaching. Can you please state your name for the record?
Marquetta Clements.
Thank you. You're requesting an adjournment?
Yes, Your Honor, to engage in some plea discussions, and I'd like to address bond when appropriate.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Master bond.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working with leaf harm reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delana. She does provide me this address. And
how'd she come back into custody?
What do you brought up?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Asked Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
time,
don't have any medical to verify what you're saying, and she was gone for about 4 months.
yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
So
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to up it? Oh, give me the file. You want to be smart? You can just let her know her bond's revoked. Mark the file. Court calls the case, People versus Abdul Latif.
Morning, y'all.
Good morning. Assistant Selector Davi Lebo, now Mr. Bility. Mr. Bility, can you tell the court your name, please?
Ability.
You need to take your hand out of your pocket. Anything you want to say to me? No, I'm kidding.
Your Honor. Your Honor, we're going to be requesting an adjournment with no complications in order to just finish verifying some discovery.
Just trying to verify. Okay. I will adjourn this then. February 12th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
There you go.
Thank you, sir. Court calls case People versus Joseph Griffin.
Your Honor, bring people.
You got that file, Mark.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under pursuant to Michigan Court Rule 8.120, practicing under Assistant.
How many times have you
Defender.
said this? Come on. You're with Canon, right? Is this the stage fright that's just going through? No? Start again.
Okay. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120, practicing under Assistant Public Defender Stephanie Cannon.
See, wasn't that hard? He's a
not.
product. Yes, you got permission to practice is granted.
Thank you. Your Honor, we're requesting adjournment in this matter.
All right. Purpose of the adjournment?
We need additional discovery, or we need a discovery.
You need it.
Yes.
Conference without objections adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Diamond Buyers. All three cases.
Morning, Your Honor, Raymond Cook with the people.
Morning, Your Honor. Edward Lucas on behalf of Diamond Buyers.
Diamond Buyers.
Thank you.
Your Honor, there's some negotiation going on. There is another case that just is authorized, and then there's another one coming down the pipeline. That's what I was told yesterday. I'm looking for an adjournment.
So, Your Honor, there was another case of financial transaction device authorized on the 26th by our office. There's also one pending in the warrant queue. These all stem from roughly the same time period. We're just getting.
So I've got one. Do we have a date set on the one that was on the 26th?
I don't believe so. Let me check my court to confirm that, but I didn't see one I was earlier. No, I'm not seeing if there's any dates set on. I don't know if it's either the
Warrant, yeah, okay. All right, that's fine. So basically, I could potentially I'm expecting one, but then there may be another one, so there may be two.
There's definitely 4 total, maybe a 5th one.
Got it. Probable cause conference, what I'll do is I'll adjourn this out to February 26th, given all of that. I'll need green sheets.
Okay, thank you.
2026, 9 a.m. Her crime will continue. And I guess so that those are tracking, if the other one does get sworn out, she's arraigned on that one, however that may occur, I don't mind setting them out to stipulate to adjourn it to this date. So I'm putting it out far enough. Hopefully we can get all that on one date.
Okay.
Okay?
Thank you.
On continue. Thank you. Court calls the case of People versus Spencer Norton, 2 cases.
Good morning, Your Honor. Edward Lucas on behalf of Spencer Norton in 1768.
And Assistant Public Defender, Tepe, on behalf of Mr.
In the other matter.
Good morning, Miss Ackerman.
Good morning.
So you're sitting there and didn't hear a word from you?
She's been talking to me all morning. Your Honor.
Yeah, she's been in your ear. Okay, I got you. Okay. What are we doing? In your name, sir?
Spencer Norton.
Thank you.
Looking to set ours for an exam. I think the other one's gonna come along with it.
That is correct, Your Honor.
Both set for exam?
Yes.
All right. Discovery is complete on both of these?
To my knowledge.
To my knowledge, Your Honor.
And do people have their witnesses available to 10th?
We'll do our best, Your
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Garwood. You may. State of Michigan. Miss, I would need check the box on here, understanding
Please.
that I'm a different sentencing judge.
That's correct,
You
Your Honor.
understand, sir?
I reviewed that with him, but I failed to check the box. I apologize.
Well, I knew it was your fault. I just want to make sure that he.
Yep.
May I have him sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Adam Atkins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. One that is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty as charged.
All right. You understand that by pleading guilty, you'll not have a trial or of any kind? You understand?
Yes, I do.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll have those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Pardon?
Yes.
You are? Were you on probation at the time of this offense?
Yes.
All right. You understand that this could be considered a violation of that?
Yes, Your Honor.
If it is considered a violation of that probation, you could be sentenced to the maximum allowable under those other charge, under that other charge or charges. You understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty to this charge?
Yes, I do.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes, I do.
On November 20th, 2024, at the location of First Street near Ann Street in the city of Ann Arbor, Washtenaw County, state of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
No.
You were intending on using it?
Yes.
You knew what you had in your possession was methamphetamine?
Yes.
All right, I can take to the higher charge in any event. All right. Sir, I do have to advise you that if I do accept your plea, if you commit misconduct as defined in Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would not be bound by any sentence evaluation or recommendation. and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
We are not, Judge.
And have I complied with the court?
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be February 17th, 2026. What time? I'm sorry. 9 a.m. before Judge Garwood. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Austin Bryan.
Morning, Kevin Nagel, appearing on behalf of Mr. Bryant, who is appearing to my right. Your Honor.
Sir, Austin Bryan.
Your Honor, I spoke to the people in this matter. I've informed my client of his rights to have a preliminary exam today. We're waiving the preliminary exam, and we'd like to bind it over to circuit court here.
Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts. Counsel, you acknowledge receipt of the information waiver treaty?
Yes, Your Honor.
And at this time, how does your client plead? Is he standing mute to the charges?
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all 3 counts. Pretrial will be set for February 10th, 2026, 1:30 before Judge Coffey.
Thank you, Your Honor.
Bond will continue. Just gonna need to sign off on the whoever. I don't know. Court calls the case People versus Ashley Alber. Who had that last case so that we can sign off on the information?
I did.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with on behalf of Ms. Albert.
Your name?
Ashley Olber.
All right. You're requesting an adjournment. You just got discovery.
Yes, Your Honor.
Probable cause conference in this case will be adjourned to February 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
The court calls the case People versus Johnny Kane.
You're ready to talk to the people?
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Payne, Your Honor.
Her name, sir?
Johnny Charles Payne.
Your Honor, this is a matter we have reached a resolution. Looking for the paperwork now. I just had in my hands. Here it is. Your Honor, Mr. Payne will be pleading guilty to an added count 2 of use of a controlled substance. I have him executing the plea form and the advice of rights. Now, I have gone over his rights. I have gone over his rights with him. Get it. And explain to him that all those rights. Your Honor, this is a matter with some labs. There was a true narc analysis. I've seen a picture of the analysis. I don't have the report. I don't know that the labs have gone to the crime lab. I've explained that to Mr. Payne. He still wishes to issue a plea, enter a plea, if I may approach. He is on parole, Your Honor. I've explained to him.
I'll get to it.
Thank you.
The plea form that the court has in its hands indicates that the defendant's going to be pleading guilty to an added count 2 of use of methamphetamine, that the 1-year offense. Upon the successful plea to that charge, count 1, the possession charge would be dismissed. There is prosecutor and defendants agree to a sentence of time served. However, I would indicate that taking the plea, I could not find a sentencing judge to that recommendation. And that, sir?
I do, Your Honor.
All right. I have him sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Johnny Charles Payne.
Sir, it is this court's understanding you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
I do.
Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I do plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights contained on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No, sir.
Are you on parole?
I am.
You understand that your entry of a plea in this case could be a violation of that parole.
I do.
You understand that as such, you could be sent back to do the remainder of your term.
I do.
Understanding that, do you still wish to plead guilty in this charge?
I do.
In this case?
I do.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They have not.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty?
I do.
All right. On the date of December 12th, 2025, location of Barton Drive near Pontiac Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
I did.
Had you used it?
I had.
And did you know what you were using was methamphetamine?
I did.
All right, sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Are counsel aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
All right, and have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied the court has complied with the court.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 27, 2026, 8:30 before Judge Perry. Our bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
You're welcome, sir. Court calls the case, People versus Renee Andrews.
Andrew, you'll be preparing on behalf of the people.
Assistant Blood Center Deputy Lee on behalf of Ms. Andrews. Andrews, can you tell the court your name?
Yes, Renee Andrews.
Thank you.
And Your Honor, we're going to be requesting an adjournment. Ms. Andrews is going to be reviewing some discovery with me.
Probable cause conference will be adjourned to February 19, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls cases People versus Kimberly Robinson.
South Carolina for people.
Veronica Glenn on behalf of Ms. Robinson. Can you please state your name for the record?
Shirley Robinson.
Thank you.
Your Honor, we're requesting an adjournment in this matter.
Private green sheet. So that one can. Basis.
Discovery.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Case of the People versus Jessica Anglin.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Miss England. Your Honor, I was unable to get into contact with Miss England. We don't have good contact information from her. It's my understanding that she has some housing insecurities, so I'm not sure if that played a factor into her not appearing today. For the record, I'd be asking for an adjournment.
Does that play a factor in not going to community corrections too?
Possibly, Your Honor.
It's
It is very cold out there. I'm sure she's trying to stay warm.
not cold. This is Michigan. Suck it up. Bench warrants will issue for the defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant, those warrants will issue immediately.
Understood, Your Honor. Thank you.
Will be adjourned to February 12th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you. Thank you, ma'am. That's called the cases of the People versus, there's a Renee Williams.
Assistant Public Defender Alexis Zerps with it on behalf of Miss Williams, who I believe is appearing via Zoom, Your Honor.
Oh, there she is. I heard her state her name. All right. Go ahead.
Is the court in receipt of the report, Your Honor, dated January 9th, I believe?
Dated January 9th, received January 28th. Yes. I have that, which indicates that she is incompetent to stand trial and likely to obtain competence
That's my understanding, Your Honor.
with treatment. All right. And you have any other evidence at this time?
None from defense, Your Honor.
No. All right. Court will order in these cases that the defendant is incompetent but restorable. I will sign an order to that effect. We'll set a competency review hearing in this matter. Yes, please.
April 30th at 9 a.m.
April 30th, 2026, 9 a.m.
Your Honor, can we briefly approach on this matter?
Sure.
Thank you.
Raymond Cook with the People.
Joy Gaines, Senior Assistant Public Defender, With and on behalf of Mr. Thomas. Mr. Thomas, would you please state your name for the record?
You're requesting an adjournment for discovery.
That is correct, Your Honor.
All right. February 12, 2026, 9 a.m. Bond continued. Thank you. Court calls case People versus Deja Banbury.
And then on behalf of people.
I'll take Daisha. She's out in the hallway. Did you get her for me, please? Your Honor, Ms. Banbury is just out in the hallway. We will, we'll bring her in.
90-day mark, April 30th. So.
Ms. Banbury, you have the lecture. Please state your name for the record.
Good morning, Deja Banbury.
Thank you. You're requesting a forensic evaluation.
Yes, Your Honor.
All right, the court will order a forensic evaluation. I'll set a competency hearing for this matter for April 30th, 2026, 9 a.m. Bond will continue.
That'll be a.
Thank you.
And I'll call your mom.
Awesome. Case People versus Leo Watson.
Alexander on behalf of people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Watson.
Your name, sir?
Leo Watson, Your Honor.
Thank you. What are we doing?
Your Honor, we'd ask the court to set this for an exam.
Discovery is complete.
Your Honor, there is some outstanding video that Ms. Zenda has told me she has uploaded. I haven't got it yet, but I have every confidence she'll get it.
If you have not received that yet, I reached out to the sheriff's department. It's surveillance footage from inside the home showing the assault. They told me they were hoping to get it today. I have not heard back yet that it has been uploaded, so I don't have that specific footage information yet.
I'd still like, Mr. Watson would still like to set the exam.
He understands that if it's not available on that date, that's not going to be the basis for an adjournment.
I have explained that to him, Judge.
You understand that, sir?
Yes, sir.
People have their witnesses available to 10. Preliminary examination in this matter will be set February 10, 2026, 9 a.m. before Judge. Fresh hour.
Thank you, Your Honor. If I could be heard on bond. Your Honor, Mr. Watson is here. I don't believe he has any significant holds where he'd be picked up on them. This is a matter where he's charged with a carrying concealed weapon, a 2-year telecommunications device charge, and a domestic violence misdemeanor. The carrying concealed weapon, the allegation is that he had a over-the-counter stun gun in his pocket when he was arrested. He has significant contacts to the community. He was he reports he was to start a job soon after the date of the arrest. He reports he can stay with his sister, who I do have an address over near West Willow. I haven't been able to contact her yet, but I'd ask the court to consider, once I'm able to do that, to release him, even if the court needed to tether him, to release him with the GPS tether. Oh, and I mean, this is a situation where I believe this is a joint apartment. I think there was a no contact order for the complaining witness to not be there, actually.
Your Honor, at this point, I would object. This case involves the victim and defendant having an argument in which he took her phone, keep her from calling police. He also assaulted her by striking her in the face with a closed fist several times, pushed her to the ground, and also tried to choke her by putting her in a chokehold that she was able to escape. Officers observed the home surveillance footage that we were waiting on, showing him assaulting her. She had redness in her face, bleeding his whole lip, and knife wounds. At this point, I believe bond said is appropriate. He does have previous dismissed related charges as well as conviction from 95 out of Huntsville for robbery and sexual assault. So I think this time bond is appropriate to set.
Motion for bond protection is denied. Bond will continue.
Thank you, Judge.
Court call case People versus Shaquille. O'Neill, Tubbs.
Andrew Childers appearing on behalf of.
Ron Brown appearing on behalf of Mr. Tubbs. He's in custody, or was yesterday. Oh, he's on Zoom.
He's on Zoom.
State your name, Mr. Tubbs.
All right.
Your Honor, have you received a,
I received a report dated January 6th indicating that he remains still incompetent to stand trial but restorable.
yes, Your Honor.
All right.
And I believe we submitted an order to Ms. Whedon. And a Mac.
I don't think I have a new order. on this. I don't have a new order. I don't know when it came in. I'll need a new order.
I'll get you one.
It's in two of the, is there one? It is. I see it. I just don't have it in the third file. All right, yes, I will, indicate that the defendant, without any other additional evidence, still remains incompetent to stand trial, but restorable. Set a review hearing April 30th, 2026, 9 a.m. Bond will continue. Thank you. Oh, what now?
This is the rest of the block.
Yeah. Courthouse case, People versus Derek White.
Assistant Public Defender Donnie Lee on behalf of Mr. White. What? You tell us your name, sir.
Derek White. All right. You're still looking for discovery in
Yes,
this.
sir. We did just receive full discovery. We just received the majority of the discovery, including the police report yesterday morning. We're still waiting for some additional information, and I would like to address bond.
Probable cause conference is adjourned February 12th, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Mr. White is currently being held on a $10,000 bond. He indicates to me he's not able to post that. This is a case that does not involve any in-person behavior. I believe this case involves text messages. He has no prior assaultive or felony offenses. He does work full-time as a delivery driver for Amazon. He tells me that both himself and his daughter are insured through that job. He's very concerned about losing that job and that insurance if he remains in custody. He does have stable local housing in Canton. He can stay out, and we have no objection to a GPS hotspot, tether, or home confinement, the ability to leave for work.
Go ahead.
At this point, I would object. This case involves victim should have valid PPO against Mr. White. He texted her saying, "Send me to jail if you want. This is not what I want." Though then sent her a picture of a credit card with her name on it that he had taken out her name without her permission. She looked at her credit report, saw that the account recently been opened and effectively restored. There was another report later after the charges were authorized, I believe the same day that the warrant request was authorized. That he had gone to the victim's mother's house and was yelling at her about this case. So I do have concerns for her safety as well as her family's safety, and the fact that he can't follow the orders of the PPO. So at this point, I would reject any modification of bond.
Anything additional?
Sure, I would just add that I believe the home confinement tether would satisfy those concerns.
How does a home confinement tether stop him from opening a credit card? It doesn't. Most for bond reduction to 9 bond will continue.
Thank you, Honor.
Calls the case, People versus Cedric Blair. Good slides.
Thank you. Good morning. Joy Gaines, Senior Assistant Public Defender, representing Mr. Blair. Mr. Blair, would you state your name, please?
Cedric Blair.
Your Honor, we received an opportunity with some additional time to discuss. I think we're close to a resolution.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continues. Thank you. Thank you.
Thank you.
Court calls case of People versus Janina Williams.
Your Honor, Raymond Cook with People.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Williams, who is now approaching. Ms. Williams, can you please state your name for the record?
Janina Williams.
Thank you. You're requesting an adjournment regarding discovery.
Yes, APA Cook was able to get discovery over to my office. I was confirmed we do have it now, so I do need time to go through it with my client, and I would like to address bond when appropriate, Your Honor.
February 12th, 2026, 9 a.m. Ask you about.
As to bond, Your Honor, I would be requesting a personal reconnaissance bond on my client's behalf. She is currently in custody on a $1,000 cash surety bond. I believe the reason why the bond was put in place was due to concerns about failures to appear. This is a retail fraud first. This is a non-assaultive offense. My client's failures to appear can be traced back to a time in which she was living out of state in Kentucky, taking care of her uncle who had throat cancer. She is now residing back in Michigan for over a year, acting as a caretaker for her 7 grandchildren, and she has actually an 8th grandchild she is yet to meet. Prior to her leaving Michigan, Michigan was her home state and where she intends to continue to reside. She has no assaulted prior criminal history. In her open cases in 14B, which one is a driving misdemeanor, the other is a possession of marijuana from 2015. She has received PR bonds in both of those. She has no other holds, and I did speak to APA Cook this morning, and he indicates he would have no objection to a personal reconnaissance bond in this matter.
And that is accurate, Your Honor. I was there at the time of the arraignment. The bond was set the way it was. There was an indication made by the magistrate at that time that if she got a PR bond on her other cases, that PR bond would be appropriate here. I do see that she has a PR bond on her other cases. I would have no objection to her having a PR bond on this case.
Personal reconnaissance bond. Thank you.
That's a PR bond.
Thank you.
You should maybe have. Thank you, Your Honor.
Thank you.
You're welcome, ma'am. Court calls case of the people versus Jessica Briscalia.
Good morning, Your Honor. Assistant Public Defender Alexis Earps with and on behalf Ms. Brisgala, who I believe should be appearing on Zoom.
Gala, oh boy. Need you to unmute and state your name.
Okay, hi, can you hear me?
Yeah, we can hear you.
Okay, Jessica Briscoe.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's gonna need to, let me just stop you. She's gonna need to appear in person. We've had a problem with this defendant. We've kicked her out of our courtroom. I think on 2 occasions. She's come back in. She was smoking.
That wasn't me.
Folks. My staff has reported that was you. And
No,
it appeared as though you were having sex on the screen.
No.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court. Okay, it really wasn't all that exciting. I just so everybody. Court does call the case. People versus Daenerys Williams.
Jacob Kennedy for the Michael Kennedy, defender for Mr. Williams, Your Honor. He's approaching the podium.
Yes, he is. Your name, sir?
Denard Williams.
Thank you. You're seeking an adjournment.
Yes, Your Honor. There's some more discovery that kind of is somewhere between us and them.
That's correct, Your Honor. It's in the cloud.
Probable cause conference will be adjourned February 12th. 2026, 9 AM.
Thank you, Your Honor.
Bond will continue. Thank you,
I'll
sir.
come.
Calls case People versus Xavier Braxton.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Braxton, who should be appearing via Zoom.
Oh, there he is. Xavier Braxton. You need to unmute, state your name. Mr. Braxton, state your name. He can't hear us. How did he know if he can't hear us?
I did prompt him.
Oh, you prompted him. Oh. We can hear you now. State your name. He can't. He's there, but he can't hear us. So can we just type to him for him to state his name? Just say your name. I don't need, really, man, just. Just say your name. Really?
I just sent him a text.
You're
message.
requesting an adjournment?
Yes, I am. Yeah.
All right, I'm gonna adjourn this matter to February 19th, 2026, 9 AM. Can you type that to him so apparently he can see that his bond will continue?
Thank you, Your Honor.
Thank you. Court calls case People versus Bernard Brock.
Is he on Zoom?
No. He's not on there.
I've been calling him.
Pardon?
I've been calling him.
Bench warrant will issue for defendant's failure to clear bond, set the amount of $10,000 cash surety. That warrant will issue immediately. Court calls the case of the People versus Corey Brown.
Your Honor, ready to go for the people?
Michael Gaddy, Assistant Public Defender for Mr. Brown, Your Honor.
Corey Brown, not present.
No, Your Honor, I talked to him Tuesday at around 3:45. He said that he's not feeling well, was going to the ER. I have not heard from him since.
He also has a community corrections violation.
Complete coincidence, Judge.
Yeah. Bench warrant will issue bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Rick Artuso.
Your Honor, ready to go for the people?
Oh, he's here.
Assistant Public Defender Chinazi Carey, Your Honor, on behalf of Mr. Artuso, who's approaching. Mr. Artuso, state your name for the record.
Artuso? This defendant actually did the right thing. He was running late.
Mhm.
He called the court.
That's right.
Came in so that everybody would know that he was, and he gave an approximate estimation of time, and he got here.
Good job, Mr. Artuso.
I appreciate it. All right, what are we doing?
Your Honor, we'd like to set this matter for preliminary examination
Discovery is complete.
to our knowledge, Judge.
All right. And would the people have their witnesses available to attend?
Sure, Your Honor.
All right. Preliminary examination in person in this matter will be February 10th, 2026, 9 AM. That is before Judge Fresh Hour.
Thank you, Judge.
Bond will continue. Yeah, go ahead.
I actually was scheduled for probation on February 10th.
Yeah,
What time?
what do you mean?
In circuit court?
Yeah, from circuit court.
Okay.
From cases before.
I can email them and let them know.
Okay, okay, I was just letting you know.
Okay, so,
He's got a circuit court matter with me, Judge, so I will.
oh,
yeah,
okay,
I will
I
let you
got
know.
it. I got it. Okay,
Okay.
thank you, sir.
Okay.
Court calls the case, People versus David Brown.
Your Honor.
Joy Gaines, Senior Assistant Public Defender representing Mr. Brown. Your Honor, I've called Mr. Brown's name several times in the courtroom and I not received a response.
The defendant having failed to appear, I'll leave the community corrections bench warrant outstanding.
Thank you.
All right, proud.
Thank you, Your Honor.
Court calls the case, People versus Linda Bryant.
Your Honor, Assistant Public Defender, and on behalf of Ms. Bryant, who's approaching, can you please state your full name for the record?
Linda Bryant,
Thank you.
how you doing?
I'm doing well, miss.
Your Honor, we're
Good.
asking for this matter to be set for preliminary examination.
Here I am again.
What you said?
Here I am again.
Here you are
Another
again.
postponement. You see, it's getting harder and harder for me to get up in here. I tell you.
But you made it.
She made
Yes,
it.
I did. Grace, by the grace of God.
Discovery is complete. Will
It's
people
my-
have their witnesses available to 10?
Yes.
All right. Preliminary examination in this matter will be in person February 10th, 2026, 9 a.m. before Judge Garwood.
I have a question. But then, who, they say they have witnesses.
Yes, I'm sure they do.
Oh, I don't think so.
Okay?
But okay,
Thank you.
okay. Thank
you,
you,
Your
guys. Have a good day.
You do the same. Court calls case, People versus Amaya Campbell.
Michael Gaddy, Assistant Public Defender for Ms. Campbell, Judge. She should be here via Zoom.
I think she is. Ms. Campbell, can you state your name, please?
Amaya Campbell.
There she is.
Your Honor, we're asking to adjourn this matter 1 week. Mr. Childers has made an offer. I've had a chance to discuss it briefly with Ms. Campbell, but we'd need some time to put the paperwork together to complete the plea.
February 12th, 2026. Bond continued.
Thank you, Judge.
Court calls case, People versus Jason Campbell.
Assistant Public Defender Dante Lebo for Mr. Campbell, who is not present. I had been attempting to reach Mr. Campbell. He reached out to me this morning and indicated he was in treatment and unable to attend. I did ask him to provide me some documentation of that. Unfortunately, I did not hear back from this morning. However, given that he was in treatment last time and indicates the same to me today, I would ask the court to consider an adjournment.
And court will issue bond set in the amount of $10,000 cash surety. That warrant, he needs to get that information to the court. That warrant will issue this Friday, the 30th.
Thank you, Your Honor. I'll see if we can get that.
Court calls case, People versus Zion Cheatham.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cheatham, who should be appearing via Zoom.
State your name, Mr. Cheatham.
Zion Cheatham.
Thank you.
At this time, Your Honor, we're seeking an adjournment to finish up negotiations. A mitigation report has been provided to the prosecution for their review.
Probable cause conference, February 19th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you, sir. Calls the case, recalls the case, People versus Michael Bedoya.
Good morning, Your Honor. Samuel Bannerpring on behalf of Michael Bedola, who's appearing via Zoom. We waive our in-person appearance, have no objection to Zoom. Sorry I missed you the first time, Judge. I had a few other Zooms going at the same time.
Sir, can you state your name, please?
Michael Bedolla.
First thing is, counsel, you're gonna need to file, because there was an attorney already on the case. I need a substitution of a.
Yes, Your Honor, that's been
Counsel.
sent over earlier this morning, so it'll get in the file soon, I think. And Your Honor, with regard to the PCC, I'm asking for one additional PCC so I can meet with my client, review the discovery, and get in touch with the prosecutor, Mr. Kennedy, on the case. If we could do the 26th of February, that would be great. I have a couple trials coming up.
Not that I'd let you pick your date, since you don't appear anyway when I call the case. Counsel,
Sorry
any
about
objection?
No objection, if Your Honor. Thank you.
February 26, 2026, 9 AM, bond continued.
Thank you, Your Honor. Have a great day.
Thank you.
You too.
Thank you.
Court calls the case of the people versus Deborah Collette.
Assistant Public Defender Alexis Zerps with and on behalf of Ms. Collette, who should be present via Zoom. Ms. Collette, can you unmute and state your name for the record?
You see, which one is she? Samson. Ms. Collette, do you have somebody that can help you unmute? Oh. She's trying. Oh, you got it.
Hello, hi. Hello.
Hello. State your
Hi,
name.
good morning, Your Honor. My name is Deborah Joanne Collette.
All righty, thank you. All right, what are we doing?
Your Honor, we're still waiting on some documentation from Ms. Collette for us to be able to provide to the people in preparation for some plea discussion. So we'd be asking for an adjournment.
So you're waiting for information from your client?
Correct. And we would turn that
So
over.
that you can turn it over.
Yep.
Gotcha. All right.
And Your Honor, if you wouldn't mind going out a little bit longer, Ms. Collette did just recently move, so she's trying to get some affairs in order, so it's taking her a while to get a hold of these documents.
February 26, 2026, 9 AM without objection. Bond will continue.
Thank you, Your Honor.
Oh, sorry. I'm sorry.
Thank you, Ms. Collette. Court calls the case, People versus John Brooks.
Good morning, Your Honor. Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Brooks. Would you state your name, sir?
John Brooks.
Thank you. What are we doing?
Your Honor, I have a plea form and advice of rights here. The prosecutor has agreed that if he pleads to counts 2 and 3, they will dismiss count 1. Restitution is still being worked out, the exact number, but we understand that that will happen at sentencing.
Please agree with the restitution on all charges. For all counts.
All right, I have a plea form now before me that indicates that the defendant is going to be pleading guilty to 2 misdemeanors, malicious destruction of a building, 1 count of 200 to 1,000, a 1-year offense, and then malicious destruction of a building less than 200 to 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. The defendant is agreeing to pay restitution as determined by the court for all counts pled to or dismissed. And he signed his sentencing judgment, but that's the court's full understanding of the.
Yes.
Yes. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, but nothing but the truth, self?
Yes, sir.
State your name, please.
John Brooks.
All right, sir, it is this court's understanding that you're going to plead to 2 charges. First charge is stated count 2 of malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir? And also count 3, which is malicious destruction of a building less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property destroyed as it relates to that count. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge before Judge Garwood in the 15th District Court. You understand that, sir? I'm gonna stop the plea at this point. This is not the correct advice of rights form. So I'll call this up in the next block. I'll pass it. Health case, People versus LaShawn Charles.
Al Chabalowski, the people.
LaShawn Charles,
Thank you.
you're welcome.
Case is this.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Charles.
What are we doing?
Your Honor, we are adjourning this matter for continued plea negotiations with the prosecutor.
That objection.
Yeah, Mr. Haynes.
Mr. Haynes, how are you? Your name again? They're gonna dismiss the misdemeanor driving an unregistered vehicle. He's going to plead to expired plate. True?
Correct, Your Honor.
That's a civil infraction, sir. Is that what you want to do?
Yes, Your Honor.
To that charge, responsible or not responsible? Please accepted. Driving an unregistered vehicle is dismissed. 135 is your total. You can go down the hall and take care of that and you're all set. Thank you. People against Jermaine Hall. Jermaine Sean Hall Jr. 25G306346A and 25G306346C. Mr. Hall.
James Schlaff on behalf of Mr. Hall, 30720.
My apologies. I also have 25G306346B. So I have A, B, and C. Two civil infractions sandwiched between or on the other end of a suspend in the middle. Your names? What are we doing on this, counsel?
I believe that we've come to a disposition, Your Honor.
You know, I don't have a problem with dismissing the suspend, but
Well, not get it down to low-ups.
no, I get that. But the defective equipment, I've asked these guys not to do this. It's 8 months old. I mean, they've been entered on his record. I'll tell you what, I'm not going to dismiss the defective equipment. If the prosecutor feels that strongly, he wants me to dismiss it, I'll just waive the fines on it, but I'm not going to dismiss.
Be fine, Judge.
If you plead to no ops, the possible penalties are up to 100 fines, 90 days jail. Costs are all of those. Do you understand that?
Yes, sir.
Are you going to stay with me now? You've been agitating me the way you don't show up in court. Now, you want to tick off judges. You keep doing this. You get what I'm saying?
Yes. I don't tick off.
Well, you're trying to. Listen, let's cut it. And if you plead to that, you're still going to pay the fines on the no ops. I'm sorry, you're going to still pay the fines on the no insurance. I'm not taking his plea on that. He's been in default on that since July. I will waive the fines and costs on the defective equipment because the prosecutor wanted me to dismiss it. I don't feel comfortable dismissing the ticket that's been outstanding for 8 months. And we'll go from there. So do you understand everything here, Mr. Hall? Did he sign an advice of rights form today? I don't think.
I gave him his rights. Did you sign an advice of rights form?
I'm going to cover him with your verbal. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. If you plead guilty, you're waiving the presumption of innocence. You're waiving your right to a jury trial. You're waiving your right to a trial of any kind. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all that?
Yes.
All right. So if you plead guilty, we're not going to have a trial. Do you understand that? Right? I don't want to confuse you.
you're pleading guilty to these charges that the court has mentioned. When you plead guilty, you give up the rights that the court has just told you. Because you're not going to have a trial. It makes sense that you're giving up your trial rights, correct?
Talk to me, Mr. Holm. You understand if you plead guilty, we're not gonna have a trial, right? You know what a trial is, right? Okay, that's all right. You ever watch any of the movies on TV where they have juries on there, and that's a trial? And the prosecutor has to prove the defendant guilty beyond a reasonable doubt. And if they don't, the defendant is acquitted. That's a trial. If you plead guilty, we're not going to have a trial. The case is resolved. We're not going to bring in jurors. We're not going to have me decide. We're not going to have anybody decide. I'm only going to decide what I'm going to sentence you to. That's it. Do you understand that?
Yes, I understand.
Okay. You fully understand everything I've said now. If not, no problem. Just tell me. I'll tell you again. We'll go over it again. Okay. You sure? All right. To the charge, no valid operator's license on person. How do you plead? On February 7 of 25, were you operating a motor vehicle in Gibraltar near Jefferson in Gibraltar at 10:27 p.m.? Listen to my question. On February 7 of 2025, almost a year ago now. Remember I was just talking about not showing up? They think you were operating, were you operating a motor vehicle on Gibraltar Road near West Jefferson in the city of Gibraltar at 10:27 p.m.? Did you have a valid license with you at that time on your person?
My license wasn't valid. I had that.
Right. You had a license on your person maybe, but it wasn't valid. You agree with that, right?
Yes.
Are you on probation or parole right now?
Probation. 400 tickets.
Was he on probation in February of 25? You sure?
Yeah.
If you were on probation on any case on February 7 of 25 and you plead guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that?
Yes.
All right. You still wish to plead guilty? Just asking. I'm not trying to trick you here. No, I'm just asking you. That's what I asked. You still want to plead guilty? This is no ops on person. I'm not sending you to jail. Anybody force you to plead guilty?
No.
All right, I'm going to accept your plea to no ops, dismiss the suspend. I'm going to waive the fines and costs, but I'm not dismissing the defective equipment. He still owes money on the insurance. Counsel, tell me who's with you. Is Sarah Ann Levitt here?
She's one that dropped me off. She's in the car.
Who is she? Is she going to let you apply the bond? Because I'm not going to be very patient with you any longer. If the bond's in her name, I want to make sure she's going to allow you to apply the bond. Otherwise, you're going to have a problem because I'm not giving you time to pay again. You guys posted 3,010% because I got tired of you not showing up 4 or 5 times. She posted it. I can't apply the bond when it's in her name. If it was in your name.
Take the money that was placed to the bond towards your fines and costs. But he needs
Permission from Ms.
Oh, okay. Yes, that's fine. You can take the money.
Well, that's nice for you to say that. You're going to have to go get her in the courtroom right now, okay? I'll go on to another case. Yeah, go get her and I'll call that one next. Purdy, Mark Daniel Purdy. 2-5. Give me 1 second here. 260-645-104. Come on up here, sir. Your name?
Okay.
Your name? So you met with the prosecutor. He's offering you to plead under section 771.1 to illegal firearm transportation. True?
Yes.
If you plead to that, and it's going to be under section 771.1, so the case will be dismissed at the conclusion of the probation department. You understand that?
Yes.
And you understand the possible penalties. Again, up to 500 fines, 90 days jail, costs are all, right?
Yes.
Did you sign, read, and understand an advice of rights form here today? Yes. If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
John? That's it. All right. You have the right to a lawyer. If you want one, I will give you one. Would you like an attorney?
No.
You waive your right to a lawyer?
Yeah.
To the charge of illegal transportation of a firearm, how do you plead?
Guilty.
On January 9 of 26 at 8:39 in the morning, were you in the city of Trenton, county of Wayne, on Medford near Belmont?
Yes.
And did you have were you transporting a firearm?
Yeah.
You didn't have a concealed pistol permit, correct?
No.
And you had, in fact, you had a magazine loaded in the center console.
I had them separated. I had the, I even talked to the prosecutor, so I had them separated. I had the gun, they weren't loaded or anything. I thought that I was doing the right thing by putting the ammunition and stuff in the glove box and they were separated, but obviously I didn't do it properly.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Please accept it. Under section 771.1, I'm going to order a pre-sentence report. You still have, if you have any firearms, you have to surrender those. Remember I told you that?
They have the only two I had, so.
Okay, good enough.
I had talked to the prosecutor too, because I know you said, no leaving the state or anything like that.
Yeah?
My kids play travel hockey and I'm the only one
Where do you have to go?
I don't have anywhere to go like right now, but they do have like Ohio, Toledo.
Can leave state to take kids to travel hockey without permission, okay? As long as you got proof of that in the car, without consent of the court, I'll be glad to let you do that, okay? I'm gonna order a pre-sentence report. We're gonna give you a sentence date. Are we gonna do this when, Heather or Amy?
It'll be February 12th at 10 o'clock.
Okay, February the 12th at 10 o'clock. Got it? Good luck.
Thank you.
Thank you. Have a good day. Ms. Medina, are you ready on this?
Your Honor.
Where is your client?
My client is in ICE custody, Your Honor, and we requested that he be written, but it didn't work.
All right, this is Jose Gabriel Rodriguez Medina, file 25F245235. Okay, your name?
Crystal Ray Medina, Your Honor, P number 77211, on behalf of Mr. Rodriguez Medina, no familial relationship, Your Honor, I'll note for the record.
Okay.
Your Honor, my client is not present here today. I am requesting a brief adjournment, approximately 2 weeks, if the court would allow, Your Honor.
Is he still in ICE custody?
He is in ICE custody. I spoke to court staff this morning. They're gonna keep making efforts to have him written and be present here for that next pretrial date. In the meantime, I'm requesting discovery and setting up a meeting with him now that I have an offer.
He wrote Judge Hessen on here. This is my case, isn't it, Heather?
It is.
And the interpreter
Yes,
didn't,
Judge.
and the interpreter didn't show up, did she?
The interpreter.
She did.
Yeah.
She did, Judge. We let her go.
I'm gonna go ahead and
So
sign
she-
the discovery order. We'll give you another date. Why don't you just set it up with Ms. Medina down the hall with her, with her. I don't need to put it on record here. And then just make sure we do what we can to get the guy out. Where's he at? Nice, custody.
Is it, I can't remember right now, Judge. It's out in.
Fine. You just tell them everything you guys were.
Request to get in here and hopefully resolve it so that it doesn't, you can just be closed out and resolved. Thank you, Your Honor.
Have a good
I
day.
appreciate it. See you.
Thank you. You too. All right. Is Mr. Hall back in here yet?
You had a good time.
I heard what my apartment's with.
Riddle, Teresa Lynn Riddle, 25T642922.
And Judge, we have, Driscoll, sorry, I cannot speak.
Detective, come on in here, will you? And call in Mr. Bologna.
Yes, Judge. How you doing? How are you this morning?
Not too bad. We'll see how this one goes. Your name, Detective?
Detective Sergeant Mark Driscoll with the Trent Police.
Yeah, call him. Your name, ma'am? Ma'am?
Oh, Teresa Bebo?
Your Honor, for the.
Your appearance.
For the record, just block 30720. Thanks.
I'd like to call you and the prosecutor in.
Prosecutors and with Judge Hess.
I could start off perhaps without the prosecutor, if I may.
Yeah.
Your Honor, I know Miss Riddle from some previous representation. She had a felony in front of this court for a preliminary exam, got found over. And after that preliminary exam, I was assigned a representative. She discharged me. There was no problems with that. It happens. And she went through a number of attorneys after that. And today, lo and behold, I saw her here. And then I was going to represent her. And she informed me that she'd rather have another counsel.
Mr. Bologna, your name?
Anthony Blanco, the city attorney, Your Honor.
All right, well, I don't know what to say on this. You don't get to pick your own lawyer. What did Mr. Schloff do wrong?
No, it's just that he did not represent the.
Well, I don't know what that means. I mean, I don't know what that means. You got to be more specific. He's a good lawyer.
All right.
Turn that microphone toward her, will you please?
He did, because then I wanted him to be aware of certain things and handle things in a certain way. And I just want to have it with about.
On the other case? Yes?
Felony case.
Has he done anything wrong on this case?
Well, I mean, it's still, he's got that previous record.
What record?
Well.
You don't have a felony record, do you, or a misdemeanor record? What record?
Just, I mean, I didn't like the previous,
Ms. Riddle?
hearing.
Can I, I'm just gonna have a candid conversation. Mr. Bologna, your name?
Anthony Blanco, city attorney.
Detective Driscoll, I got a disturbing call the other night about accusations that Ms. Riddle has levied against me.
Yes, Your Honor. If you need, for the record, I can send you a copy of.
Need it. I know, I'll say it. I don't even know the lady. She was accusing me of sexually assaulting her, and she was accusing me and another judge of conspiring to hire a hitman to have her killed. I can still handle this case fairly. I think there's other issues going on. I'm ordering a competency exam on this, and I'm going to order it now, and I'm going to continue the bond, and we will have a competency exam, and that's it. I was like taken really aback. I mean, I've had accusations that are false levied against me in 32 years, but that's ridiculous. So, ma'am.
It was a tribute for the newspaper.
I think that you shouldn't get into the details at all.
Competency exam is ordered. I'm going to keep you on the case. You don't have the right to hire and fire court-appointed lawyers. If you're not happy with Mr. Schloff, you're going to have to be more specific. I'm not prepared to discharge him now. We'll see how the competency results come back. And we will go from there. And competency exam ordered. We'll set this for arraignment and pretrial. I'm guessing that they're taking at least 2 months, right? So why don't we set this up for sometime in the middle of April? And
It'll be on a Thursday as well.
yes. And I'm not going to remove Mr. Schloff. You haven't given me any reason. I've been around Mr. Ma'am. I've been around Mr. Schloff enough in my career. I have a great deal of respect for him. I would find it hard to believe that he did anything wrong. And when we come back, if you still want him discharged, you're going to have to be a lot more specific about what he has done wrong in this case, okay? But I'm ordering a competency exam. You have to go down and get evaluated, okay? I think this is for your own good. We'll set it for a, ma'am.
You're gonna send me, I've already had,
I can't hear you, ma'am. You got to talk into the microphone nice and loud.
I've already, worked with what I was trying to do was file charges with the Trenton Police Chief. And he has refused for the last 2 years to file any charges or complaints. And then when they arrested me and that chief spit.
All right. I don't want to hear it.
I'm gonna file that.
I don't want to hear it. I don't have anything to do with that. Listen. I'm going to send you for a competency exam. I think we can help you. Ma'am, Do not argue with me, please. That's what I'm ordering. We're gonna give her a review hearing date in the middle of April, and we will go from there.
She received a letter from.
The forensic center. So we need to make sure, do you still live on Charlton Road, apartment 119?
I am, almost into Trenton Tunnel. They're just.
Ma'am, I just need your address.
Yeah.
You live at 1795 Charlton Road, apartment 119.
Address this general delivery because.
Ma'am, I can't tell the forensic center to send it to general delivery and have it gift to you. Tell
Judge,
me your.
If I can
What?
interrupt, she does not reside at 1795 any longer. She was evicted from that residence. She has a PO box in Trenton. I know she's moved from hotel to motel over the last several months.
What's her PO box?
Ms. Riddle, if you can provide that.
What is it? 248?
Is there a specific?
So we'll send it to 248, but I hope you go and look at it every day, because don't come in here when you don't show up for the exam and tell me I never got it. I didn't check my PO box. I don't know what else to tell you. You got what I'm saying?
Is there a specific post office where that box is?
Just in regular post office.
It's in the city of Trenton, right?
Yeah, I'm sure.
Yeah, Trenton Post
I
Office.
just wanted to make sure too.
So that's where we're gonna send the mail. We're gonna set a review hearing in the middle of April. When will that be, Heather or?
Judge, we could do either April 9th or April 23rd.
Let's set it for April 9th at 9:30 in the morning. You go down the hall, get your notice, but you have to show up for the forensic. I want you to listen to me very carefully. Sometimes things go awry in our life. We have problems. We're going to try to get you some help. Just let me try to help you, will you please? And I think you'll find out this will work better. Detective, if there's something else to add, I'll be glad to listen. I see no reason for me to recuse myself at this point. I think it's just.
No, I asked you to recuse when I was in charge before. And,
You asked me to recuse myself?
You say before, during the pendency of this charge?
I don't think she's ever been.
It was when that girl that she had 3 vicious unleashed dogs.
Ma'am.
That attacked me.
Ma'am.
And I asked you to recuse.
Well, okay. I have to have a basis for it. I have to either be biased for you or against you. And ma'am, please don't interrupt me. You have a tendency to interrupt people. There's nothing here that makes me biased for you or against you. Okay? Your allegation's so ridiculous, it's laughable. I'm not getting into this anymore. Go down the hall, get your review hearing date. I'll address the issue with Mr. Schloff when you come back. You got to show up for your examination and we'll let it play out. That's it. Have a good day.
Can I request the FOIA in the court hearing?
Request what?
FOIA from that court hearing,
What court hearing?
the one where I asked you to recuse yourself.
Ma'am, I don't even know when it was. I don't remember. Well, then you request it, you pay for it, and we'll be glad to type the transcript up. I don't care if you did or not. I'm not biased for you. I'm not biased against you. This is the way I do my job every single day. I'm not going to hear it anymore. Back away from the podium, go to the exam, go down the hall, get your notice, and I'll address all these issues then. Thank you. Jermaine Sean Hall Jr., 25G306-346 A, B, and C. Back away from the podium, Ms. Riddle. All right, come on up here, ma'am. Ms. Riddle, back away from the podium, ma'am. Now, don't make me do something I don't want to do. Back away. You go to state as a lawyer, detective. You know that?
Sometimes it's easier, Judge. I understand.
Oh, they think what I do is easier. Come on up here. I'm just kidding. Mr. Hall, your name again. Ma'am, your name? Are you Sarah Ann Levitt? Yes. Tell me that and respond to that. You have 3,010%. Are you going to let Mr. Hall apply this to the bump, to these fines? You posted a bond of $300. That means he has $270 to apply. I need your permission as to whether or not you're gonna let us apply the bond to payment of fines and costs. Okay, good enough. You're gonna go down the hall and deal with them in a second. Let's sentence on the no wops. Anything, counsel?
Nothing more except he's been trying to clear up his record.
Anything, sir? 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3.25 or 60 days. You have a bond of 3,010%. By law, we keep 10%. 270 will apply. I'm going to give you until March the 1st to pay the other $55 on that. On the other case, I told you I'd waive the fines on the defective equipment, file A, I am. And on file C, you're to pay $50 per week. $50 per week, beginning March the 15th, okay? And if you don't have the money, you come talk to me in person on or before the due date, or if you know how to use Zoom, you call the court, say, can I jump on Zoom with the judge? I'll be glad to talk to you.
Make a change. Just relax. Take it easy. You're still young. That's your fault. There's so much you have to know. Find a girl, settle down. If you want, you can marry. Look at me. I'm old, but I'm happy. All right, let's fix this. I hope. All right, I think we got it. Thank you all for saying good morning. I did restart. Good morning, Vivian.
Good morning.
Our defendants aren't in the courtroom yet, so I'm going to take the client that is here. Are you Dixie Sharp, now known as Dixie Beers?
I'm Dixie. Well, I was Dixie Beers. I'm Dixie Sharp.
All right. Well, you got arrested here in St. Joe County in December for operating while intoxicated and open intoxicants in a motor vehicle. The file number here is 252729. SD. And the open intox is .30, I think. Yes. In Michigan, operating while intoxicated is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. You do appear to have a valid Florida license. You had contacted the court after this arrest. You went back to Florida And I've allowed you to appear by Zoom, which is unusual. But I wanted to get the case started. The public defender is not here yet, Ms. Sharp, but my recommendation here would be that you plead not guilty. And I set this for a pretrial with an attorney. At some point, you're gonna have to come back to Michigan. What was your reason for being in Michigan?
I was visiting family.
Say that again.
I was visiting family.
All right, so you have family here?
Yeah, I grew up in Sturgis.
All right. Do you have any objection to my suggestion that you simply plead not guilty and I get a lawyer to help you with this?
No, sir.
I'm gonna show you pleading not guilty. I'm gonna appoint an attorney. You're gonna have to come back here for a pretrial for April 3rd.
April 3rd.
I'll set it out an extra month. At 8:30. Is your Bloxham Cutoff Road address still correct?
Yes, sir.
All right, we'll send you the information. I want you to call the attorney and make an appointment to discuss this case with them. You need to make arrangements to come back to Michigan
Okay.
for that April 3rd pretrial.
Yes, sir.
But we got the case started. So all right, I'll send you that information. I want you to call the attorney, make an appointment to discuss this with them. You still need to get fingerprinted on this. So when you are here, we'll take care of that. But I've set it out till April. Hopefully the weather will be better and you need to make arrangements to be here at that time. All right, you're good to go. Thank you.
Thank you.
We have 3. All right. Good morning, Mr. Truckee.
Morning, I'm a public defender today.
Well, thank you.
So Miss Sharp, maybe on Zoom?
Yes.
Okay.
We just did her, she pled not guilty and I appointed a lawyer for her.
All right. I have Mr. Clark here. Abraham Clark is going to be a not guilty plea and a non-attorney pretrial.
All right. Where are our Spanish speakers?
They must be in the hallway, so a few gentlemen
All
might
right.
be.
Let's take care of Mr. Clark and you bring everybody in. All right, Abram Clark, would you come forward, please?
Yes, sir.
Abraham Clark is charged in file number 251260 with driving with no insurance on June 24th. He failed to appear for a previous arraignment. There's a bench warrant out for his arrest in that case. In file 251261, the same date, June 26th, he's also charged with driving without a license. And in June 26th, boy, they charge him 3 different ways with not having a license. No operator's license, no cycle endorsement, no ops in possession. He can't be convicted of all 3 of those. He's missed multiple court dates. There was a pretrial set, bench warrant issued. He posted bond on January 9th, got arrested. then we gave him this date. He has a previous ticket of no license expired from earlier in 2025 where he owes $220. So defendant is here. I'm going to recall the bench warrant. So you're asking me to simply set it for a pretrial with the prosecutor?
Yeah, Mr. Clark is presenting me with a valid insurance registration and current driver's license, so hopefully he can demonstrate that to the prosecution.
All right, well, have a seat. Let me see if we can get the, you have a valid insurance license and registration now?
Correct.
All right, very good. All right, have a seat. We'll see if we can get the prosecutor to take a look at this. All right, we have with us this morning our interpreter, Ms. Vivian Montero. We had 3 cases of drinking driving where I think people needed an interpreter. 2 of them are here.